Justices of the Appellate Division, Fourth Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 696, People versus Irwin. Mr. Sarando, can you hear us?
I can hear you, Your Honor. I can't see you, but I can hear you.
You're breaking up a little bit. Maybe get closer to the microphone.
Can you hear me now?
Yes.
Okay, but I can't see you.
You're not missing much. If there's a camera, you want to click that on, that might get you to where you want to be. Up. We're not. There we go. You're back.
I'm back, but I can't see you. But I will proceed, Your Honor.
Okay, please do. Thank you.
Thank you. May it please the court, John Sarando, Syracuse, on behalf of the appellant. This is an appeal from a judgment of conviction for the crimes of manslaughter and assault following an Alford plea. The defendant received 12-year determinate sentence. The first issue I'd like to indicate that the waiver of appeal was totally invalid. The waiver form itself indicates that the sentence and conviction are final, and more importantly, when discussing the waiver, the trial court indicated that there's nothing you or your attorney will ever be able to do in the future to open this case up. And you won't be able to legally or factually challenge the plea or the sentence. And we submit, as this court found in the Davis case, that that's an absolute bar, and the waiver is invalid.
Very good. We'll take a look at that, counsel. Why don't you move on to your other arguments regarding the search warrants?
Yes, Your Honor. The search warrants, there were 4 search warrants. And I think when you look at the number 1 was the entire rear building, the sanctuary, and it's my understanding that the residence was separate. The second one was for the defendant's phone and person. The third one was for the whole building, but the residence was separate from the sanctuary. The entire fourth one for the entire rear building. We submit that the defendant has standing in regard to these search warrants. Number 2, because for warrant number 2, he was the subject thereof. 1, 3, and 4 were her residence and where she performed her pastoral duties.
Is there a preservation issue here?
I don't believe so, Your Honor, because the trial court addressed all 4 facets of the search warrants. The issue is therefore preserved since the trial court expressly decided the questions raised on appeal. And I think in the Bailey case and the Smith case cited in our brief, that allows us to raise 1, 3, and 4 insofar as it's concerned.
Very good.
All of the search warrants, Your Honor, as the case, this court's case in Saley and the Galpin case, you need a specific offense, a place to be searched, and you have to specify the items to be seized by their relation to the designated crimes. In the Galpin case, the court specifically said that violations of New York state penal law is an overbroad warrant, and that's what they had here. They had sections listed, very numerous sections, which violated the particularity requirements. There was an awful lot of discretion left to the executing officers in that regard. and therefore the search warrants should be looked at and the decision in regard thereto reversed. There was also issues we submit in regard to the defendant's Alford plea. As the court is aware that the plea is the product of a rational choice and it's based on a strong record of actual guilt. The defendant here never provided the correct narrative indicating that it was the nature of an Alford plea. As the court is aware, the Alford plea is basically, from time immemorial, the defendant accepts a sentence based on the fact that they would feel that they would be convicted on the evidence. That phraseology was never utilized here in this case. We also submit that this is a case of connected pleas, which this court in Shaw indicated requires special care. This is a little different than the Shaw case, however, in that the defendant had to plead guilty so that other people could plead guilty. And that we submit is inappropriate.
Mr. Sarando?
Yes.
Mr. Sarando, can I ask you a question? Your client's got in 8 years already.
Yes.
She got sentenced to 12. Your argument, she wants a new trial. She wants to go to trial on a murder charge that exposes her to 25 to life. That's what she wants here?
She wants her appeal to be decided on the grounds that we have raised, Your Honor. She is adamant that the proceedings against her were not fair, and
I'm just trying to make sure that her remedy here is a trial. There's no dismissal or anything.
Well,
on the plea issue, on the Alford plea issue.
On the Alford plea issue, but however, I got to consider the search warrants in regard to that as well, and that could juxtapose a better defense for her in that regard. Mm-hmm. I think when she was asked, "Did anyone threaten you?" and she said, "Not physically," and there was no further inquiry. So we submit that it's in regard to the Shaw matter. In addition,
you should be mindful of your time, Mr. Sarando.
Yes, Your Honor. Insofar as the withdrawal was improperly denied, she wanted a fair trial, a fair judge, and according to her, she didn't get it. The counsel never made a motion to withdraw the plea, and we submit that it was so serious that it defied not her effective assistance of counsel. Insofar as the sentence is concerned, I think it's very important that the court look at Dr. Lessling's report insofar as the genuine psychiatric disorders, and she served long enough of a sentence, and the sentence, if the court does not do anything else, should be modified down to time served. This was her first offense, and if there's no other questions, we'll rely on our brief.
No questions, counsel.
Thank you.
Morning, Your Honors. Brad Oser for Oneida County today. I'll launch into the search warrants briefly if I could. Each of the warrants was supported by adequate probable cause. The judge's decision on all four of them, and I guess I'll recognize that although the defense disputed the search warrants on only a sort of a narrow ground, the court did conduct a full review and ruled entirely on the sort of full basis for the probable cause. But the judge's decision lays out all of the information that it had before when it was reviewing the warrants. And there's really a wealth of information, some of which I'm not sure is entirely captured in the record, but the court's decision does explain everything that was before it. The warrants, the different warrants may have described or laid out a different part of the particular address to be searched. And I'll recognize that the phrase sort of the entire building, at least in search warrant 3, I think it was, is maybe suggests sort of like the entire building, including that rear sanctuary area. However, as modified by school, residence, business office, I suppose if we think about it in comparison to like a normal church, a more traditional church, there's clearly a difference between the area where like the worship would occur and the business would be conducted or the people might live. So I think that description is actually perfectly sufficient and describes, really breaks down that property into the two areas that it entailed. With respect to the Alford plea, the defendant's statements at sentencing when she attempted to withdraw her plea, I think kind of elucidate why she made that response of, well, I wasn't physically threatened. I think she was of the opinion that the people's requirement that all 4 defendants plead at the same time to the respective offers, in her mind, that was psychologically coercive. However, there's...
Right, there is something to that, is there not?
There is.
Unusual in court. I don't get the need here where the court says, and the people say, if you, Ms. Defendant, want to plead guilty, you can only, all 4 have to plead guilty or all 4 go to trial. One of the co-defendants was a relative, the 2 were close friends. That seems a little coercive, does it not?
I don't see it that way, Your Honor. I recognize that certainly, I would assume, makes that a harder decision for the defendant, or at least she's feeling pressure because she wants to certainly help her own family member, close friends. But our law allows for these linked plea agreements to occur. That's Shaw and Fiumefreddo. There's also discussion in plenty of case law about the fact that any guilty plea is a psychologically stressful event. I'm not sure that this, forces it across the border into some sort of coercive category. If the defendant really well and truly felt that she was innocent, I would assume that would apply for the other co-actors, since she seems to be the head of the organization from what the record reveals to me. So I'm not sure how she can really say that this was psychologically coercive, more so than any other guilty plea that we might typically see. And her statements at sentencing, I think, as far as I can see, groundless complaints about violations of a gag order or the judge being biased or things of that nature, I think suggests that her protestations were a little bit more just sort of regretful hindsight rather than an actual grounded complaint in some sort of abuse of discretion or actual coercive plea agreement that the people offered. So I believe that the withdrawal of her plea, or motion to withdraw her plea, was properly denied, and I think it also speaks to the fact that the Alford plea was valid. And I think the sentence here was certainly appropriate in light of the facts. Thank you.
Thank you, counsel. Case 698, People versus Jordan. Counsel, welcome. Can you hear us?
I can, Your Honor.
I can, Your Honor.
Very good. Proceed.
Good morning. May it please the court, Melissa Swartz on behalf of Appellant Gregory Jordan. I know the court's familiar with the facts and the arguments I've made in my brief, so I will keep this as short as possible. I think the prosecution's strategy in this case was to paint Mr. Jordan as somebody who was aggressive and adversarial in order to show that he was the person that had slashed Maywalt in the back of the ear. The way they went about doing this, I think, was error, and I don't think it was error that was harmless. I think they did a couple things that I pointed out in point 2, which had no basis. The first was getting 2 testifying officers to talk about Mr. Jordan's demeanor after the fact in regards to the police officers. So they both testified that when he was getting arrested, he was screaming, he was yelling, he had to be handcuffed to the bench. There was, as defense counsel noted when he objected, there was no relevance to that whatsoever, only to make it look like he was an aggressive person. But as this court knows, there was tons of testimony that he had been thrown to the ground, he was fighting with some guys when the police arrived. So the fact that he was agitated, I don't see had any relevance but to prejudice him. The second thing that the prosecutor did was in closings, without any fact in the record whatsoever, she pointed out that he had been fired from that establishment when that question was objected to and was properly sustained, again, to paint Mr. Jordan as somebody who was completely adversarial. I don't think those are harmless in light of the proof and for the reasons that I discussed in point 1 that I won't go into, but I weave definitely some issues that I don't think were pointed out to the jury or properly considered by the jury. And lastly, if you believe
Counselor, if I can interrupt you for one moment,
of course.
There's no contradictory evidence here that your client lunged at the victim and slashed his neck.
I guess the contradictory evidence would be, one, I think Mr. Schnoo, who claimed at trial that he was completely blacked out but remembered the knife, he's also standing beside Mr. Jordan, according to Mr. Lena. So there's a possibility that Mr. Schnoo is the perpetrator of this crime. And then Mr. Maywalt, as I pointed out, credibility issues.
Right, Schnoo's hands weren't bloody, but your client's were.
And the blood on the hands that the people pointed out, I think was completely overblown. If you look in the record, he has a singular cut on his left thumb, which could have been being thrown to the pavement when he was surrounded by all those guys. He then has blood on this part of the L, probably from holding his thumb to stop it from bleeding. So the idea that blood was on his hands from this slash, from this 12 to 16-inch knife that was never located, I think defies credibility. Lastly, if this court believes my client committed this crime, I think it wasn't, the circumstances surrounding it, including his alcoholism, wasn't properly considered by county court. The people offered 5 years on an attempted murder second. He was acquitted of that. I mean, I think I can absolutely see why he was acquitted of that, but he was offered 5 after trial. He received the same sentence on an assault second. If this crime was committed by my client, it was fueled by alcohol. He took great steps, as noted by defense counsel at sentencing, to resolve that issue, went into treatment, and I think of the reduction of the sentence in light of his lack of criminal history warrants a reduction. Thank you.
Thank you, counsel. Counsel, proceed.
Thank you. Good morning, Your Honors. Chris Valdina for the DA's office. The primary evidence that the defendant was aggressive, of course, was that he stabbed somebody in the neck outside a bar. His behavior and demeanor after the incident was probative of his state of mind, was properly received. To the extent that we sought to get into that a little further, there was an objection sustained. The comment during the summation, again, there was an objection sustained to that immediately, and no further. There was a request for a mistrial was on different grounds, so that was covered in light of the evidence, harmless. And beyond that, we'd rest on our brief unless the court has any questions.
Thank you, counsel.
Thank you, Your Honor.
Case 700, People versus Allen. Counsel, can you hear us?
Yes, I can hear you, Your Honor, but once again, I saw you the last case, but I can't see you on this case. But that,
Okay, you can proceed, though, without seeing us. Counsel Schwartz, can you hear us?
Yes, Your Honor, thank you.
Very good. Proceed.
John Randall from Syracuse for the appellant. This is an appeal from a conviction for sexual abuse crimes, 7-year determinate sentence following a jury trial. The district attorney's cousin sat on the jury, and the trial court indicated it made a mistake during questioning the jury. When the cousin raised her hand, he thought it related to police, not consider the remaining individual entities in the initial question, even though it usually does. And the cousin was, as the court knows, was disqualified as a matter of law under 270.
Well, can I just stop you there? When you say disqualified, that suggests that under no circumstances could that prospective juror serve. Isn't it the law here that this prospective juror and any relative of the district attorney could serve unless challenged for cause?
No, because they're in the relationship. And I think the statute says,
It says you may challenge for cause people on different grounds, may challenge, and one of the grounds is you're related to
but all of
one of
the
the lawyers.
All of the cases that I found indicate that it's a bias that cannot be waived. It can't be waived. It's an automatic bias that the courts strongly uphold, and we submit that it's also a matter that's considered under the interest of justice. And even as the Walters case suggested, even though the issue was not preserved, given the importance of a defendant's right to an impartial jury and concomitant right of the public at large, the jury appear impartial, the interest of justice jurisdiction should be exercised and a new trial ordered.
Counsel, doesn't this, let me make a suggestion here. Doesn't this open up kind of a problem if you have defense attorneys not following up on a question that they should follow up on, and therefore setting up reversible error that they pocket and then move forward with the trial?
No, I don't think so, Your Honor. We would submit that the mistake was, as the judge indicated, it was his mistake because he improperly forgot to fully question the jurors as to their qualifications, or the attorneys could examine them. In addition, I believe we raised in our brief that counsel was ineffective for failing to further follow up on the questions. So we admit that.
Look, this usually doesn't happen because in most cases I've seen, the court or one of the lawyers will ask the prospective jurors, the entire panel, does anyone here know any of us? Know the defendant, the prosecutor, the defense lawyer, the judge? Does any of you, do any of you know us, or any of you related to us, something like that? That apparently didn't happen here. And that's what led.
That's correct.
And then there was just a general question, does anyone know anyone in law enforcement? A lot of hands went up, apparently. And there was no specific follow-up with everybody, and that led to all this.
I believe he asked specific questions of the police, and one of the questions was district attorney's office, and then he never followed. It was a group raising hand, and he never followed up with the specifics of his question. And I think that's where he indicated that he made a mistake. And
I think Justice Whale's question was, then you have a situation like this, there were a lot of jurors who responded yes. A defense lawyer could just sit there and not follow up with one of them and have a free new trial in his back pocket or her back pocket.
Well, no one knew that the defendant, no one knew that the district attorney's cousin was on the jury other than the cousin herself and the district attorney who pointed it out after trial. So I think.
But counsel, what we do know here is that the question was asked in such a way that it included the district attorney's office,
Yeah.
and hands went up.
Yes.
And defense counsel was in the room and saw the hands go up and did not follow up with any questions relative to the juror number 9, right? We're dealing with here.
Yes, the counsel did not, but I think.
And you're taking, but let me just clarify, but your position is that's a non-waivable problem, first of all. And secondly, even if it is waivable, your issue is it goes to ineffective assistance.
On this record, but yes, I think when you look at all the cases that we cited in our brief, the job application in the DA's office, the social relationship with the DA, the juror needs to be aware of the relationship, which we have here. The trial judge's wife, the court did it in the interest of justice, socialized with the DA, even though the DA wasn't in court. The person was found to have, I think the language they use is implied bias. And I think this Judge Hafner at the time had been reversed by the Court of Appeals in the Fury case based on the implied bias of the juror in regard to a relationship with the police department, even though her husband or her, people did not.
Counselor, I'm sorry. What if juror 9 had said, I am related to the district attorney. The district attorney is my brother, and I can't stand him. Could the defense have waived the objection, waived the challenge, and let that person sit?
No, Your Honor. The defense, it's a non-waivable problem due to the implied bias of the relation. And we submit that the courts consider this.
We'll take a look at that, Mr. Sarando. Do you want to move on to your other point?
The other point I'd like to discuss relates to one thing I'd like to say before we move on. When we argued this case before in Syracuse, the court indicated that they could foresee reaching this issue in the interest of justice on the direct appeal. So I want to point that out. The other issue we'd like to present to the court today concerns the grand jury. And I think there's an indication with someone indicating that they knew the defendant, and the questioning of that juror. First of all, it occurred, it violated this court rule in Richardson and Simpson by examining the juror in front of the grand jury. As the court has indicated, that's supposed to take place out of the presence of the grand jury, and we submit that the inquiry did not demonstrate the impartiality of the juror. So the indictment itself is suspect.
The defendant had a copy of the grand jury proceedings but didn't raise that issue. Is that right? Is this a preservation issue?
I think there was a motion raised, but I don't think it was specifically to this issue. And I think the last case I had on this, I don't think the defendant raised the specific issue as well, but the court did consider it. This court did consider it. and I think it was a Lewis County case. Other than that, we'll rely on our brief and the record that reflect a juror that should not have been sitting on the case.
Thank you, Counsel. Counsel?
Good morning, Melissa Swartz on behalf of the respondent, the people of the state of New York. I want to start off by saying I'm acutely aware of why this is an issue, right? I don't want to minimize it and say, oh, it's okay that, you know, the district attorney's cousins are left on juries. But I think this court has been asking Mr. Sarando the questions that were really the basis of my argument. And one, that this issue can be waived because it will lead to gamesmanship. And if it leads to gamesmanship, that can't stand. So that's why it is a waivable issue.
Doesn't the statute explicitly say 270.201C of the CPL? It says a challenge for cause and objection to a prospective juror and may be made on the following grounds, one of which is the relationship between prospective juror and a defendant. So that suggests it is waivable. If you may make doesn't say you must challenge a juror there. Isn't that our answer?
Exactly, and that's what Justice Del Conte's hypothetical was actually the hypothetical I was going to give, right? What if that cousin said they hated Greg Oaks and they didn't do anything about it? Would that be that reversible error, even though they chose not to do anything with it? So it's waivable.
But why wouldn't it be ineffective assistance of counsel that you don't explore it further to find out what the relationship is?
On this record, I don't think we can get to ineffective assistance of counsel. I think that's something that needed to, one, in the 330 motion, there's no sworn affidavits from either trial counsel. So I'm not sure why that wasn't in the 330 motion explaining why they didn't follow up. Two, I think it needs to have a 440 hearing because I do imagine a strategy where they didn't follow up not only on juror number 9's questionnaire where she indicated that she knew somebody in a law office, but also her questioning. I think there is an imaginable strategy behind that, and that's
what would that strategy be? Because not only did he not follow up with juror number 9, he didn't follow up with any of the jurors that raised their hand. What might that strategy be?
That he decided he wanted to focus on other questioning, right? That his strategy went to the other questions that he asked, and the answers to those questions he thought didn't matter. But again, I don't know what Mr. Spano's or Mr. Kazmarik's strategies were. I don't, and that's why
you're saying this issue, you're not saying it's a losing issue in effective assistance. You're saying it should be brought in another form, but the lawyer understand maybe prospective juror number 9 gave some other answers that seemed favorable to the defense. Maybe his or her background seemed to be favorable, but we would need to hear from the lawyer what the reasoning was, if any, for not following up. And it might well be ineffective, but you're just saying we can't make that call here.
Exactly. And unless the court has any other questions for me, I ask you to affirm the conviction and vacate the stay.
Thank you, counsel. Case 701-702 in the matter of Juliet A.W. I believe we're waiting on Mr. Riley. Very good. We have all counsel on board. Can everybody hear us?
Yes, Your Honor.
Yes, Your Honor.
Mr. Riley, you're on mute.
Sorry, Your
Very
Honor.
That's fine. You can hear us, I trust?
Yes, I can. Thank you.
Very good. Proceed, counsel.
May it please the court, Lionel Hoydu, I'm representing the mother in this case. We're arguing that the family court erred by granting summary judgment and terminating her parental rights without a fact-finding hearing. There was an issue of fact, namely whether her mental health had improved over the passage of time. This appellate division is familiar with this mother and prior proceedings by virtue of your May of 23 decision upholding the finding of neglect in this case.
Counsel, let me kind of, if I can, narrow the focus of the argument a little bit. We have a situation where there's allegations that the mother had an intellectual disability and that she also suffered from mental health issues, correct?
Exactly.
Yeah. In the court below, can the court below, is it fair to read the court below's decision that if we find either one of those grounds sufficient, that's enough to move forward with this, with an affirmance on this?
Well, I think
did the court below consider both of them and therefore collateral estoppel requires us to look at both? I'm just curious as to your thoughts on that.
I would argue that the latter, Your Honor, that the judge specifically, this idea of derivative neglect, that she's unfit as a parent, was based upon, one, she had this mild intellectual disability, and number two is her mental illness, her mental health. And no one is arguing that her intellectual disability is going to significantly improve over time, but both psychologists who examined her indicated that there was a possibility that her mental health would improve over time. And they specifically talked about getting mental health counseling, parenting class, and then avoiding certain men.
But if those are two separate grounds to terminate parental rights, intellectual disability and mental illness, and you've acknowledged intellectual capacity isn't likely to improve over time, there was just a finding previously in another proceeding with respect to the mother's older children that she was intellectually incapable of caring for them. This child is then born soon thereafter. DSS says, well, we already have a finding on this. She's incapable of caring for her children based on her intellectual capacity. We don't need another trial. We want collateral estoppel. What's your argument against collateral estoppel based on just the intellectual capacity ground, not putting aside mental illness? Or can we separate them, I guess is the question.
Well, I think when you look at what the court decided down below, Your Honor, it's relying upon the psychology reports. And they treated the two together. They discussed them as one part, but two components of one part that make her unfit to parent. And both of the psychologists who submitted reports and testified indicated that she could be a adequate caretaker for children if she took certain steps. So the experts are indicating that if she takes certain steps to address her mental illness, that is sufficient to overcome her mild intellectual disability.
I got you. So it's a confluence of the two. If you take away one, then the other one can't stand.
That's my argument, Your Honor, yes. I think that in this case, when you look at the dates of the examination, the one psychologist examined her in 2012 and the other one in 2017, both testified in 2018, but they both left open the possibility that she could be a adequate caretaker for children if she addresses certain issues. And that's our argument, is that the experts are saying that she can essentially rehabilitate herself, and yet she's being denied the opportunity to even present proof that she has done that. And that's all we're asking for, is that opportunity.
We understand the argument, counsel. Thank you.
Thank you.
Counsel?
Yes, Your Honor. Stephen Riley of Counsel for the Department of Social Services in Cattaraugus County. Basically, it's our contention that the motion for summary judgment met the test to allow the court to proceed and allow it to have a summary judgment basically that there had been identity of issues, which has necessarily been decided in a prior action. And also that there's a full and fair opportunity to contest that decision. Basically, any quotations were not taken from the psychologist's reports, but rather from Justice Sullivan's findings of facts and conclusions of law that were put in, where he basically put down what the psychologist testified to. And both psychologists testified in 2012 testified that the mother suffered from intellectual disability and also a personality disorder. And in 2018, Dr. Siebert testified that the mother suffered from intellectual disability and a personality disorder. Both of them are very hard to overcome in the foreseeable future, if ever. Basically, this court also made a finding in 2023 on the
Counsel, let me stop you there for a minute. Your part of your argument was that they're hard to overcome, if ever. But isn't that a question of fact that has to be determined after a hearing with current information for the court to consider, as opposed to dated information relative to her ability to parent?
Well, I'd also add to the fact that in 2013, this court found on the neglect case for the same child that, in fact, the mother had not overcome any of those disabilities. And in fact, they upheld the neglect finding on the fact that the mother suffered from intellectual disability and also a mental health problem. And that was in 2013. The mother still hadn't overcome it at that point.
Can you overcome intellectual disability? Is that even possible?
That's a hard question, Your Honor. Basically, it's a lifelong process. The intellectual disability usually established when somebody's very young. It's based on their IQ and their ability to learn. And both psychologists testified to the fact that the mother had extreme disabilities as far as learning and as far as her IQ.
Right, but what the appellant's point is that those findings were made years and years earlier. And the argument is that the mother is entitled to review of her capabilities at the time of this new proceeding. And
I would
you
add,
can't go back, like some of these reports were made, I don't forget the number of years, 8 years before perhaps, and a lot can change in 8 years is their argument.
the one was made in the last one was made in 2018. But then basically the child was born in 2019, 1 year after that finding was made. There was a neglect petition filed at that time with this court, upheld in 2023 based on the mother's intellectual disability and her basically her personality disorder. I would also note the fact that this motion had been brought previously. My mistake, I attached the wrong petition. We had to bring it again, which is a year later. So, but there's been no showing by the mother in any of her answering if there's any proof whatsoever that she had gone through any more counseling or had done anything to achieve the results of trying to ameliorate the situation that brought the kids into care.
We'll take a look at that, counsel. Anything further?
No, Your Honors. Thank you.
Thank you. Counsel Connell?
Yes, thank you, Your Honor. I have the pleasure of representing the subject child here. She's 5 years old now. She's a delightful child, and I would concur with Mr. Riley that there was a full and fair fact-finding hearing. The mother sat through it both with the prior 3 children, then with a 4th child. So there has been fact-finding on this, not just the reports from Dr. Siebert and Dr. Zuckerman. So that there was a fact finding that decision was upheld by this very same court. So I think it's absolutely proper to affirm this decision. And I cited in my brief matter of Yeshua G, which I think is on point. So I'd ask the court to affirm and give my client permanency.
Is your client, she's still with the same foster family waiting adoption?
She is awaiting adoption, yes.
Have you observed the mother with the child at all since they took her when she was only a few days old to determine the extent of the intellectual disability?
No, I was not the AFC at any of the trial levels. I do have information about the mother that was supplied to me by the foster parent. But that would be totally outside of any record.
Yep. Yeah, we're not interested in that at this point, counsel. Anything further?
Nothing further, thank you.
Thank you, counsel.
Thank you.
Case 704, Naji versus the Honorable Barrett.
Morning, Your Honors. David Abbotoy from Mr. Naji. It's our position in this litigation that the denial in this case is based on non-statutory criteria, making it invalid. I think there's multiple layers to how that comes about here, but I think I'd like to start by addressing something in my that was raised in my opponent's respondent's brief that really only comes up in one sentence, but I think kind of encapsulates a bit of the conflict here. My opponent raises the issue and says that whether or not Mr. Naji had to reveal these conversations with the police comes down to a credibility issue. And naturally, we don't want the court to draw that conclusion because of a certain deference that's afforded to the lower court. Our position here is that there's a predicate question that has to be answered in this litigation, and that is whether Mr. Naji had any duty at all to, any statutory duty at all, to reveal mere conversations that he had with the police that didn't implicate criminal activity on his part.
If I may interrupt you, you don't disagree that the application was inaccurate or untruthful?
The written application did not, well, I have two ways of answering that, Judge. First, our position is that there was no duty to.
I understand that.
Okay.
I understand that argument, but the application itself wasn't true.
The written application did not provide perhaps all the information that it called for. However,
Wait, let me just finish that, which is the basis for the licensing officer's denial of the pistol permit.
Yes, that is their basis for the denial.
And do you disagree that the statute requires that the application be true in all respects before a permit is issued?
Well, I do disagree with that, Judge, because the application can only request material statutorily authorized information. And so our position is that it's really twofold. One, Mr. Naji had no duty to respond to non-statutorily authorized information because, for example, the legislature doesn't believe that those factors that are not requested or not required by the statute are material to licensing, and that the statute further says that the statute and the decisional case law goes along with it would say that the licensing official or the sheriff's department performing the investigation can't meaningfully expand the criteria upon which a person should be denied.
Counsel, I understand that argument. Let me ask this question though. Let's assume that the applicant takes that position, that this question that I'm filling out is asking for inappropriate information. They're not allowed to ask for this information. Does that justify putting down false information in response to the question? Or should the applicant skip the question or put an explanation in there that I'm not answering this because I don't think it's appropriate? Which of those is, or all of them is, if you're arguing that, is appropriate?
I think the statute and the statutory process sort of guides us to how we should view what Mr. Naji did and perhaps how we should have handled it. I think as lawyers, we can probably think of many ways to handle that and say, I'm not sure I'm required to answer that or how to put that. He put nothing because he didn't think he did anything wrong. When he got an attorney, and this is going back to Judge Del Conte's question, in fact, some of what I wanted to add to this as well, when he finally got a lawyer, well, that's part of the application process too, and that's why initially my response to you, Judge Del Conte, was to say what was initially asked of him on the written application wasn't provided in all fullness, but the part of the application process that includes him having consulted with counsel is also part of the application process. I see it as really being two parts.
And I understand that part of the argument. In other words, the applicant's making an overall application, and you're saying the application itself is only part of it.
The written application, yes.
The written application, only part of it, thank you. But he supplemented that. in this particular case with additional information.
And the legislature envisioned that's happening.
I understand. Let me go back to my question. Even assuming an applicant has a good faith belief that the information being requested is unauthorized, they have no authority to ask for that information, is your argument that he's justified in putting out false information then because they're asking an inappropriate question?
I don't believe that. I think you have to conclude that it is false, meaning willfully false. You have to also conclude that Mr. Naji understood that this was looking for wrongful conduct on his part that was embedded in conversations that he had with police, when what we know based on the conduct at the hearing and the involvement of counsel and his own statements to the lower court is that he did not understand the meaning of that question.
Right, your point is that, look, his answer no to the question, have you ever been interviewed by the police, so forth, law enforcement, his answer no was not true, but it doesn't mean he was lying. It doesn't mean he was trying to mislead. And that a layperson reading that, have you ever been interviewed by law enforcement, except to exclude traffic summons and so forth, a reasonable person, not a lawyer, might look at that as, am I a suspect? Did I do anything wrong?
Right,
Not just was I ever, now this is a man who's never been convicted of anything, never been arrested for anything, gainfully employed, owns a business, 4 kids, married, and so forth. When he checked no, he misunderstood that. That's different than being misleading or lying.
Yes, and I think some of the reason why I'm having maybe some difficulty answering your question, Judge Whalen, is because I think it's obvious that generally speaking, no, people should not put willfully false information on an application. I truly can't say that unequivocally. Willfully false information on an application, no, that is not to be permitted. I think the proof in this case indicates otherwise. The legislature wants you to consider those additional parts of the application process. But behind all of that, I think what we're really looking at is his fitness to possess a weapon. This gets to some of, I think, how my opponent has tried to parse out the subjective nature of the court's ultimate analysis in concluding that he doesn't have the character to possess a weapon. What we're talking about is whether or not he correctly understood whether this question was asking for, potential criminal activity on his part or just some periphery involvement he had in someone else's criminal activity.
So is the practical response then, the burden then shifts to the reviewer of the application when they see no to that question to follow up, because there may be additional information there and they need to follow up with the applicant on that? Is that what you're saying?
I think that's what the statutory process involves, Judge. But what I think happened here was that the lower court sort of truncated that review and said, well, your initial written application said no, it clearly shouldn't have, and therefore I've decided you don't have the character to possess a weapon.
Or is either that, the court said you answered untruthfully to one question, therefore you lack the good character, or, in your view, she impermissibly started making credibility determinations based on FIFs that were hearsay upon hearsay, one of which said there was an allegation hearsay, perhaps double, triple hearsay, that he threatened to shoot a tenant of his unless he vacated the premises. That was the most concerning one.
Right.
Your view is that if the lack of good character is based on that, that's improper, because that person never testified. And your client testified, had an explanation. But if it is, it sounds like it was more a result of you lied on your application, therefore you lack good moral character.
I think, in fact, my opponent sort of concedes that in the very first page of the respondent's brief, not by saying that the application was denied because he made untruthful statements in that initial, he doesn't say written application, but we are referencing the written application. Of course, the whole application process, he would have been truthful overall, but that it was only based on the responses to the written application and not with respect to the conduct underlying it. So I think, yes, Judge Lindley, not only are there these various hearsay and proof problems underlying all of that, but based on what the respondent has said the nature of the decision was and the basis of it was, even if you sort of assume all those facts, because she doesn't doesn't ultimately deny on the basis of the nitty-gritty of all of that. The just not making the proper response in the written application doesn't go to dangerousness at all, which is sort of what my opponent says is if a subjective analysis is allowed, that's the core analysis that the respondent was permitted to take, dangerousness. Just making this incorrect response on the application is not enough, particularly when everything else we know about this person is that he's kind, nice, trustworthy, peaceful. And the Supreme Court has said that normal, ordinary, law-abiding citizens are presumptively entitled to possess weapons. The result in this case almost seems like a non sequitur, particularly in light of the fact that when he does get a lawyer and come to court, he says what I think is reasonable based on the way that question is. Look, he didn't know he was looking for his mere kind of tertiary involvement in criminal activity by others. When he said interviewed, sort of understood it to mean he was the target of some investigation.
If he honestly answered that question, well, not honestly, but if he accurately answered it, it would have been based on his prior profession. He worked in, ambulance service, whatever. He worked in a store where there were a lot of crimes. It would have been, there's not enough room on this form.
That's true.
It would have been page after page of every time he had contact with the police and it was questioned, which could be interviewed, it would have been here's like 30 pages. Every time I've ever come into contact with the police as an EMT, as a business owner.
Right, Judge, and I think
owners.
the fullness of his later disclosures and his openness with the court during the hearing itself and in the letter submitted to the court indicates that he was willing and able to discuss these things in a way that made sense, and that really the only problem was his misunderstanding of how that question applied to him. But when it came down to the time to do so with the proper information, he was able to explain those things, and it really did become clear that the wrongful activity was someone else's or other people's wrongful activities under those circumstances, and didn't really relate.
With the exception of I'm going to shoot you, I'm going to kill you if you don't leave.
But
he wasn't the victim there.
The way the lower court sort of looks at these things is to look at the police reports only, and of course I haven't seen them, and that's a separate issue raised in my brief, but the way that whole scenario turns out is the other guy gets arrested for attacking Mr. Naji in the presence of the police, and they take no action with respect to him.
And there's an order of protection issued against that guy, right?
I'm sorry?
And there's an order of protection ultimately issued against the tenant.
Yes, and so the police resolved that in his favor. To the extent there was any fact-finding on this issue, the police did it on the spot and decided the other guy was the problem and not Mr. Naji.
Counselor, I'm not entirely sure how the background checks operate, but what if his contact with law enforcement had been the ATF? The issue here is that the background was done by the Monroe County Sheriff's Department, and they apparently had access to all the RPD information.
Right.
But what if it was the FBI or ATF or something else, and he said, no, I've never had any contact with ATF, and maybe he did have a lot of contact with ATF. Would that be a different analysis here?
I mean, I don't think so statutorily based on what the statute is commanding him to reply
But isn't
to.
that I think the point that the respondent is making here is that question assists in conducting the background investigation. If I've got to talk to the DEA or ATF or FBI, I can do that, because that may not be in our database, whatever Monroe County can access.
Oh, I see your question, Judge. I mean, I don't really know how a layman would understand how the nuts and bolts of how the sheriff is going about, or whether they're trying to shave something off to conceal something. I really don't think there is in this case in particular, any view that Mr. Naji did that with some knowledge that he might be depriving the police of information that they already had access to, because they did have access to all this stuff, and there's no way he could hide it from them. That's sort of the core problem here is that, I mean, I understand the hypothetical that, perhaps he could, I guess, choose not to reveal information that could not be available to the sheriff's department, but I don't really think that is, that's what ended up happening here, nor was there any real danger of that, because when he finally, I think the way this would be covered in the statutory process is when he finally gets a lawyer to help him, that's all coming out. And moreover, I think practically speaking, there's probably no way that the sheriff's department is going to miss any of this because they actually have access to all of the information that they would need to know Mr. Naji's response. And moreover, I just want to make sure it's clear because in some places, even our discussion of things in the brief gets a little muddied. It really is only asking whether he has been, quote, interviewed. And so contacts with the police and things like that, I think that the phrase interview is what really kind of ends up confusing things because it does make it seem like he's the target of some investigation as opposed to just having conversations with the police in passing, which he would have had many of over the course of his career.
Anything further, Counsel?
No, thank you, Judge.
Counsel.
Thank you.
Good morning, Your Honors. Kevin Hu on behalf of the respondent. So there's really only one issue in this proceeding that is properly preserved for this court's review, and that is whether the denial of petitioner's pistol permit application was arbitrary and capricious. But here, respondent's determination was not only based on undisputed evidence in the record, but it was also consistent with well-settled precedent holding that when there is a false statement in the pistol permit application that is material to the application itself, that can form the basis of a denial. So as an initial matter, I think we can all agree that the written application contained a false statement.
I would agree with you that it was false, but it's different than being knowingly false.
That's right, Your Honor, and it's worth noting that all of the evidence that petitioner cites was a defense that he presented at the hearing and as well in his written submission. But respondent made a credibility determination rejecting those defenses, and I would direct the court to pages 5 and 6 of the hearing transcript. She first notes that the question itself, the plain language of the question itself is far broader than arrests. And second, she notes that even though he may have had more interactions with law enforcement than the average citizen, this is not a case where he disclosed some but forgot others, but didn't disclose any at all.
All right, so let me ask you this. Let's say somebody applies for a permit, pistol permit, and in the past they've been subject to stop and frisk by the police. The police stop and frisk him multiple times in certain parts of the city, find nothing, let him go. He's questioned, would you got anything? And he's let go. No arrest, no evidence of any wrongdoing. He applies for the permit. He answers no to this question. He can't get a permit based on that. He answers no even though he was stopped and frisked, perhaps illegally, was found to have nothing. Like Mr. Naji, never been arrested, never been convicted of anything. That guy is precluded from getting a permit because he didn't disclose these stop and frisk interactions.
Your Honor, those circumstances would not preclude the applicant from obtaining a permit, but he would still be required to disclose them in the first instance so that the licensing officer can consider those circumstances as a mitigating factor. The problem here was that there was no disclosure at all, and respondent therefore reasonably concluded that the failure to make an initial disclosure could be evidence of an intentional decision to mislead.
Even some of these instances in these field investigation forms, FIFs, Mr. Naji was the victim. Right?
That is correct, Your Honor.
He was a victim in a lot of them.
That's right. He was either a victim or witness.
So if you're a victim and you don't disclose the fact that you've been assaulted or robbed or threatened, then that's it. You can't get a permit.
I think a licensing officer would be justified in deciding the application either way, because again, it would be a mitigating circumstance. But what makes this case different is that there are 3 instances involving where Mr. Naji is alleged to have engaged in threatening or concerning conduct. And because the good moral character definition is key to dangerousness, those 3 incidents were unquestionably relevant to
right. That's where we're getting to. Is it sounds like if there was determination made that he actually threatened this person, I'm with you. Not sure the evidence would support that. This is, again, the one he threatened with a gun, the order of protection allegedly was issued against that person, not Mr. Naji. The police investigated and Mr. Naji was never charged. So we're saying, based on that hearsay, that it's enough, that somebody makes an allegation, doesn't show up at the hearing, the licensing officer can deny Mr. Naji a permit based on these hearsay allegations that apparently the police didn't even believe.
Your Honor, if I could make two responses to that. So the first is that respondent never reached the point where she had to make a determination as to whether the alleged conduct actually occurred, because the untrue statement was enough to deny a petitioner's application that is consistent with well-settled precedent. And second, Mr. Naji's explanation as to that particular incident merely presented another credibility determination that respondent could have resolved against him. So Mr. Naji's explanation is that police witnessed that individual hit him and then issued an order of protection. But if that were true, the sheriff's investigation would likely have recovered records corroborating that account. And so there would be a basis for respondent to still disagree in spite of his explanation.
So, counsel, if I were sitting down there making a decision and I would make a different decision, how does that impact this argument?
That is, Your Honor, it is irrelevant to whether a different decision could be made, because the standard of review is ultimately whether the decision was arbitrary and capricious. That looks to whether response determination was rationally based on the record, and here it absolutely was. It was based on undisputed evidence, and that is consistent with well-settled precedent, holding that a false statement on an issue that is material to the application. And Justice Lindley, I would emphasize that it's not just the misstatement, the false statement here, it is a false statement on an issue that is material to the application. Those three incidents involving concerning or threatening behavior are unquestionably relevant to petitioner's fitness to have a pistol permit, and that is why the combination of those two factors form the basis for the determination.
Anything further?
I'm happy to answer any questions the court might have about the unpreserved claims, but otherwise we would urge the court not to reach them based on well-settled principles of issue preparation.
Thank you, counsel.
Thank you.
Case 706, Trathan versus American Rock Salt. Mr. Ginsburg? Oh, not there yet. Very good. Counsel, can you hear us?
I
Counsel,
can, yes. I can hear and see you, Your Honors.
And we can hear and see you also. Counsel, proceed.
Good morning, Joshua Lippis on behalf of the appellant plaintiffs. Plaintiffs' claims were dismissed against one of two defendants, American Rock Salt, after the defendant made a motion to dismiss for failure to prosecute and file a note of issue. The failure of prosecution was connected to defendant American Rock Salt's demand for a deposition. As we stated in our papers, the plaintiffs did not schedule a deposition because they had not yet received the discovery responses, the paper discovery responses of a co-defendant, Axo Noble Salt. Plaintiffs, as detailed in our papers, plaintiffs made numerous efforts to obtain this paper discovery, including filing an RJI, requesting a court conference, numerous letters to Axo, and then ultimately making a motion to preclude Axo from supplying this evidence at trial if they do not provide it. Prior to that motion, there was a court conference where Axo promised to provide this paper discovery, so the motion was held in abeyance, but ultimately Axo failed to provide the thousands of pages of documents.
Right, counsel, I understand all that with respect to the other defendant, Axo, but American Rock, ARS,
yes,
complied with all discovery requests timely.
They did,
and it would seem like, I know hindsight's 20/20, but it would seem like if your client's position was, we don't want to have Mr. Trathan deposed until Axo complies, a phone call, email to ARS saying, look, we understand that you have this notice to depose our client. We want to hold off till we get these other discovery records. Maybe ARS could facilitate that with their co-defendant. Instead, they just did not respond to any of these notices. They just ignored them altogether.
ARS certainly knew about our discovery challenges from the court conferences and were aware of the motion that plaintiffs had made, and they took no steps to help facilitate the obtaining of that discovery. Not that they had to or they needed to, and I certainly agree with you, a phone call should have been made saying, we'll give you the deposition after. we obtained these documents. I don't disagree with you. Unfortunately, it was not made. But I think that the position that my client wanted to review these thousands of documents and these responses prior to deposing is an inexcusable reason for the delay in the deposition.
Of course, the other side's going to say, well, why not? Why didn't you move for relief with the court? The note of issue was supposed to be filed based on the third scheduling order by a certain date. There was no motion to extend. There was no relief sought there, and the deadline came and went.
Yes, Judge. I mean, we did make a motion to get AXO's information, documents. And when the defendant made their motion, we did go to the defendant and say, we'll provide you the deposition. The court and ARS did not do the same thing that they did with the case of AXO. They didn't put it in abeyance and say, or give a conditional order and say, if you don't get the deposition done in 30 days, we're going to move forward with this motion. None of that was done. As far as the note of issue, you're correct. We should have moved to extend it or contacted the court in some fashion.
There were two problems here. It was one, the failure to comply with the notice of deposition, and the second one was the note of issue. You got two problems there.
The reason that the note of issue was not filed was because, as you know, a note of issue says that all paper discovery is completed in the case, and it wasn't.
Right. Couldn't you have done a conditional one, like we've seen on some occasions?
Judge, it wasn't me who was handling the case at that time.
You're in a tough spot, but
and I unfortunately could not speak to him about why he did or did not do the things that happened. Maybe a conditional order could have happened. A conditional note of issue.
Isn't the appropriate remedy here to go back to the court? I mean, there's a court order that says file the note of issue by a certain date, right?
Yes, and
I fully understand the argument. Wait a minute, if I file that note of issue, I'm saying with the certificate of readiness that we're ready, we're done, discovery's complete, and I can't sign that.
Right.
And so there's a remedy here, and the remedies go to the court and say, before the date ticks off, we need to get a new order, amend this order, and here's the valid reasons why.
Yes, Judge, and I agree, and maybe the fact that our office did not do that constitutes law office failure. I agree with you that could have been a step that was taken to avoid the situation that we are in here.
Well, can I ask you this? There seems to be two general claims in the complaint against both defendants.
Yes.
One is that the negligence of the mining operators with respect to the smaller pillars caused a collapse in 1994.
Right.
And that caused the water to come in and all sorts of problems for your client's land, allegedly.
Yes, Judge.
Those allegations don't relate to American Rock Salt, which didn't. True, they don't. When did American Rock Salt take title to the land?
American Rock Salt first rented property from Axo Noble and then eventually bought the property out.
Years and years after the mine
Years later, but we don't know
Decades.
when they rented it because we never got the documents from Axo. We don't know when they purchased it because we never got the documents from Axo. We don't know when they started storing salt piles outside the property, which blew across onto my client's property.
You still got AXO on that cause of action.
We do, Judge.
And they're
The judge
still in
did
the
not,
game,
did
right.
not, did not dismiss Axo's
The other
cause.
cause of action deals with, the other major claim is a pile of salt apparently was on the mine property and it would blow onto your client's property and cause problems for the trees.
Trespass, nuisance, damage to the.
That's the one primarily directed at ARS.
It was directed at both because the
At
salt
both.
pile existed and changed over time when both defendants
Right.
owned the property.
But as far as ARS, that's the main claim against them, because they didn't own the mine in 1994.
I don't know when they started leasing the property, but yes, yes.
Okay.
Any further, counsel?
Yes, Judge, I just want to briefly touch on one point made by the defendant's reply brief, where they went at lengths to say that the motion they made was by default or unopposed. And I reviewed the order, I reviewed the decision of the court. Nowhere do they say it's a default order or was unopposed. And they actually, even though the filings were late, included the filings in the order as documents that they reviewed. So I believe that claim by my opposing counsel is without merit.
The court considered the attorney's affirmation in opposition to American's motion for dismissal and also the attached exhibits, as well as American's reply papers. So the court considered all those below.
Right, so it was not unopposed, I mean, the judge even wrote in, as you can see in the order, in the record, wrote in filings number 61 through 71, showing that they did review those filings. So I just wanna make sure the court was
though they
aware-
were submitted untimely.
Even
the court
though they
gave
were
a break
submitted
and-
untimely, that it was not unopposed.
Very good.
All right,
Thank you, counsel. Mr. Greenberg?
It pleased the court. We do think the appeal should be dismissed because the underlying motion was granted on the basis of plaintiff's default. Supreme Court did not say in its order that it considered those papers. It said that those papers that you were referring to were submitted. They were indeed submitted. That's correct. And I think the telltale sign that this motion was granted on default is that Supreme Court said dismissal is appropriate, quote, even considering plaintiff's late response. You only would say that something is appropriate even considering something else as an alternative holding or dicta, if you will, because that thing was not itself entitled to consideration in the first instance. But going to the merits of this case, the decision should be affirmed if the appeal is not dismissed, because dismissal for failure to prosecute was a sound exercise of case management discretion. I think all the reasons that your honors explored with my colleague really prove up the point. I just want to highlight two of them quickly. I think the most salient point here is that plaintiffs offered no excuse whatsoever for failing to timely request an extension of the court-ordered note of issue deadline, not simply a flimsy excuse or an inadequate excuse, but literally nothing. And then, even if your honors are not inclined to accept the missing of the court-ordered deadline as a jurisdictional default type of defect, the fact that plaintiffs missed their court-ordered motion response deadline certainly supports the lower court's discretion. After all, this case is all about plaintiffs' failure to comply with court-ordered deadlines. And
counsel suggests law office failure is a reasonable excuse, cite some case law on that. Do you disagree?
I agree that law office failure in general is a reasonable excuse to certain defaults and the like, but there's no showing here that there's any law office failure. Law office failure with respect to, I think counsel was talking about the failure to request an extension of time to file the note of issue. Law office failure is something that falls behind a file cabinet. An attorney gives something to a clerk or a paralegal, and because of miscommunication, it's not submitted on time or the like. Here, there is literally no excuse. We don't know if it's law office failure. That's what my friend on the other side says now. All we know is that, and all Supreme Court knew, is that without explanation, plaintiffs did not did not move to extend the note of issue deadline. We also think that on the facts of this record, even going beyond the failure to request a timely extension, there's really no justifiable excuse for failing to timely file the note of issue itself. Justice Lindley, for all the reasons that you discussed with my friend on the other side, there were plenty of remedies that plaintiffs could have availed themselves of in order to get what they thought was this outstanding discovery from AXO. But I think another point is that, my friend on the other side in his brief mentions that in September of 2022, during the midst of this motion practice, the plaintiff said, okay, American Rock Salt, let's talk about dates now for scheduling Mr. Trathan's deposition. But according to the record in this case, Mr. Trathan and the plaintiffs still didn't have the outstanding discovery from AXO at that point. That just shows that this outstanding discovery from AXO was never the necessary prerequisite to making Mr. Trathan available for deposition that my friend on the other side said below that it was. So it really impeaches the core premise of my friend's argument and the argument he made to Supreme Court.
Well, let's say we accept your friend's argument with respect to the excuse, and we say law office failure. Then we have to examine the merits, do we not? The possible merits of the causes of action.
I don't think.
If you wish to be heard on any of that?
Sure, absolutely. Although just parenthetically, I don't think you would have to examine the merits. It's law office failure is not an ipso facto justification for missing deadlines. It is something that a court can, in its discretion, take into account. If Mr. Lippis wanted to argue law office failure and actually say in real time in an affidavit that that's what this was, presumably he would have done so before Supreme Court, and Supreme Court would have had some materials on which to exercise discretion to excuse a purported law office failure. There's nothing in the record about that, so there really can't be an abuse of discretion on that point. But I do want to get to Your Honor's question about the merits. Plaintiffs, with respect to their claim against American Rock Salt, relied on, in large part, an attorney affidavit made without personal knowledge or any sort of expert environmental knowledge, speculating that, quote, eventually a plume of contamination will cover the entire property. Now, while I don't even think that an attorney affirmation without personal knowledge would be sufficient to show merit, even talking about historical observations of the property, a fortiori, if the claim is that some sort of environmental damage or event is going to accumulate in the future with respect to this property and contaminate it over time, certainly, I mean, even Mr. Trathan's lay testimony, had he given it, I think we would have been making the same argument. But certainly an attorney affirmation, a bare attorney affirmation without personal knowledge, speculating on this future event is not sufficient for plaintiff to carry his burden of showing merit. And the Supreme Court below, in addition to observing the lack of a reasonable excuse for filing the note of issue on time, or any excuse for requesting an extension, also observed that plaintiff had not demonstrated a meritorious case against ARS, and that determination too was not an abuse of discretion. I think I'd want to close by saying that based on the evidence that Supreme Court had before it, based on which is what plaintiff chose to provide and not to provide with respect to an explanation for why they didn't seek even to timely request an extension of the note of issue deadline, Supreme Court's ruling was well within its broad case management discretion under CPLR 3216. And for that reason, if the court does retain jurisdiction over the appeal, we respectfully request that the decision below be affirmed.
Thank you, counsel. Case 707, Virtual Palir Compounds LLC versus Aurora Ridge Dairy LLC.
Good morning. May it please the court. Ed Yankelunas for the appellant. This is a case that involves a contract to do repairs and install products on biogas system on a farm. It turns methane from cow manure into electricity. That's rather unusual, I admit. There's a limited warranty provision in the contract. There's also an exculpatory clause in the contract that prohibits consequential damages. Now, after discovery, both parties moved for summary judgment. Judge Walker had the case below. The judge denied our motion, the appellant's motion, to enforce the exculpatory clause, granted my opponent's motion for partial summary judgment as to liability on his counterclaim. Now, there are multiple questions of fact, and what's unusual about this case, I submit, are 8 questions of fact acknowledged by Judge Walker in his decision. I'm going to focus on 4 right now. 1, whether the parties, or whether the defendant provided instructions or specifications to my client for the tank works. That's disputed. Number 2, the extent of the parties' pre-contract discussions concerning the purpose for the tank that goes to the contemplation of the parties with respect to consequential damages under Kenford versus County of Erie. There was work done by a third party, the party that actually provided the equipment to the farm, LFM Manufacturing, I forget the exact name. LFM whether LFM's work was within the original scope of work or not. That's disputed. The court acknowledges that. And this, I think, is the fourth, I think, most important. The allegation is made that my client conditioned on the agreement to do or offer to do more repair work on charging for the work, which would be contrary to the limited warranty. Now, the judge refers to an affidavit submitted by my client, James Minner, that disputes that, but then the judge says, and here's the problem, it's belied by an email, belied by a January 24, 2017 email of Mr. Minner, the same guy who did the affidavit. Number one, that's an assessment of credibility. You can't do that on a summary judgment motion. But then when you look at the email, it doesn't say what the judge says it says. It says, it shows the parties were still working on a new scope of work and were discussing a new scope of work. The defendant said, what will the scope of work be after we agree on the provisions? And my client refers to a new scope of work. Therefore, there's a question of fact. You can't grant a summary judgment motion under those circumstances, and it's so important here because based on this finding of fact by the court rules that we repudiated the warranty. But I'll get to that. I'll get back to that in a second. But there's also questions of fact raised by affidavits. Now, the defendant submitted something called the Shat report. That was basically the court referred to it as an expert opinion. My opponents say, no, it's a fact finder. It's a fact affidavit by somebody with expert qualifications. But the court said we never responded to it. We're just not doing it. The record reflects that Jeff Minner, a mechanical engineer with VPC, my client, submitted a point-by-point response and a 10-page affidavit. It's another fact affidavit by a person with expert qualifications. The court just ignored it, never referred to it, and didn't explain why. That's a problem. That's a reversible problem, I submit. The court also said that it's undisputed that there were leaks in the tank after the work was done by my client. Well, it is disputed. There's an individual named Eric Guild who submitted an affidavit who was present when the leaks were tested. At the conclusion of work, they said there were no leaks. Once again, the judge didn't refer to that affidavit. For some reason, I guess he just ignored it. And we don't know why, because the court didn't say why. But it disputes that point. There's another question of fact as to whether or not there were leaks after the work. Now, the judge was correct in saying, yes, the warranty limitations apply, they're conspicuous. The exclusion of consequential damages are applicable, they're conspicuous. They're not hidden in some agreement. And then proceeded not to apply those limitations and proceeded not to enforce the consequential damages exclusionary clause. Now, I think this goes to the Kiatkowski case of this court. Under Kiatkowski, as I read that decision, I think I read it correctly, in order to find that a warranty has been repudiated, as Judge Walker said here, there's got to be some demonstration that the warranty failed of its essential purpose. That's Kiatkowski. There's no reference of that discussion in the court's opinion. But then I think, in addition to the fact that whether or not the warranty has been repudiated is a subject of a question of fact, the court then misapplies Kiatkowski again with respect to the consequential damages provision. The court says, this is Judge Walker, I'm paraphrasing now, of course, under Kiatkowski, it's permissible to not apply a consequential damages limitation when there's a breach of warranty. Kiatkowski says the opposite. It certainly says the opposite, that when a consequential damages clause and limitation of warranties clause in a contract stand on their own. Whether or not a limited warranty fails of its essential purpose is a question of fact. Whether or not the warranty or a consequential damages exclusion should be applied is a question of law. It should only not be applied when there is a question of unconscionability. The judge never even discusses unconscionability below. So I think there's multiple questions of fact And I want to close by mentioning the Kenford case. One of the additional questions of fact, as I've mentioned, is what did the parties discuss? What was in the contemplation of the parties with respect to the purpose of this tank? Did my client know the tank was going to be used to generate electricity to be sold to the grid? That's a disputed question of fact. We don't have to decide it today, of course, because it's a question for the jury. So there's several questions of fact that should have been the basis for denying this motion. The judge acknowledged them. The biggest problem, of course, I submit, Judge, is, Your Honors, finding that the warranty limitation was repudiated based on this alleged conditioning of, willingness to do repair works on charging for the work, because probably would have been wrong if it was within the scope of work, the original scope of work, but it wasn't. At least it's disputed. We don't have to decide it now, but it was disputed. The judge acknowledges it was disputed, makes an assessment of credibility, makes a finding of fact, notwithstanding the dispute, and rules on that basis.
It's not raised in the briefs that I picked up on, but it's just kind of a basic question, because you did highlight that email relative to the scope of work. We'll have to decide on the scope of work. Is there a fundamental problem with the contract in this case on a failure of meeting of the minds relative to not agreeing to the scope of work? And does that have any relevance to the decision of the court?
I think what happens is the scope of work changed over time because there were problems with the tank. There were leaks, or there were repairs that had to be done after the work was done. My client came back at least twice, and then the question was what had to be done to keep this tank working.
So the initial issue with respect to performing the interior fiberglass work, that there was a meeting of the minds on relative to the fundamental contract.
I think so, Judge. Yeah. I think the judge had it right below when he said that too.
Yeah.
I believe he did.
Was the scope of work, was that outlined in the sales order from July 20th, 2016? Is that what you're referring to?
Well, I think it is to the extent that the purchase order lists various items of work to be done with corresponding prices, and I guess that would have been the scope of work, because nothing else could describe the scope of work.
So
But that changed.
the sales order is the operative contract here.
I'm sorry, Judge?
The sales order is the operative contract that defines the scope of work, would you say?
I would say the purchase order does. The purchase order is what describes the work initially. The terms and conditions of the agreement corresponding or incorporated into the purchase order is where the warranty comes from and the damages.
When you say purchase order, is that different than sales order?
I'm sorry, Judge?
When you say purchase order, is that different than the sales order?
I think it's we're
Same
talking
thing?
about the same thing.
Okay, just want to make sure.
Anything further, counsel?
No, Judge. Thank you very much.
Thank you.
Good morning. May it please the court. My name is James Sonneborn. I'm with the firm of Bousquet Holstein. We represent Aurora Ridge. I will say I agree with counsel that the factual issues here are what I'm going to address, leave to the brief the address the legal issues. So I think the facts are particularly important. I suppose they are in every case, but in this case particularly so. Before, I guess even as Mr. Yankelounis' client is saying, well, we want to make this right. That's a paraphrase. The owner of this business, VPC, was at the time a practicing attorney, and I suspect that he had in his bag of tools one thing, a hammer, and so he saw everything as a nail, and so he started a lawsuit. The document in question, to the extent that, and we've addressed this, that this is not a UCC Article 2 sale of goods case, although that's the only limitation here that they want to rely on. It is not that. It says that that if the plaintiff appellant chooses to, and there is a dispute, they can repair the product, they can replace the product in the contract, or they can return the money. And before either of those things happen, they initiate, but it's ultimately this lawsuit. I think they've established, and I can't imagine anyone negotiating the contract anticipated that after 3 tries, they couldn't do the work. and they didn't return the money. Their contract gave them those choices. They repudiated both choices. They started the lawsuit even as one of their employees is acknowledging that the work is defective and they want to make it right. With regard to the suggestion that they're asking for more money, if it was new work, why would you give somebody a 50% discount? Hey, there's some additional work here, here's what it's going to cost. That's not what they said. I think that the trial court was correct. Its job is to consider all of the credible evidence. And when somebody submits an affidavit that says, we didn't know it was a double wall tank, it's actually in the complaint, I believe, and we didn't know anything about methane gas and we didn't know what it was used for, and the record shows the generator here is the size or bigger than a tractor trailer, and it's sitting there near the tank. It's a methane tank. They didn't know that was dangerous if it leaked, according to them. They didn't know it was for. They knew that the scrubber was cleaning the methane to go into something that was going to run a generator. They didn't know. The court might have articulated that differently, but you get to take a look at that, and I don't see how you can come to the conclusion that any of that is credible. Now, there is one witness, we referenced this in the brief, he is not a disclosed witness, he's not there, and all of a sudden he shows up in an affidavit. And the court didn't consider that, is it? The court should not consider that. Why it didn't? It didn't because they didn't disclose the witness. I might have written the decision differently and been more articulate about that, but at the end of the day, the evidence here is pretty clear. It leaked, and it leaked, and it leaked, and finally, my client went back to the company in Florida that, by the way, as the record reflects, they initially contacted and referred them to the plaintiff in this lawsuit because they were too busy to do the work, and they came up and did the work. And in one of the affidavits, they're now disputing if there was a leak. So I guess they're saying that my client hired somebody from Texas to fly up and do repair work, paid to have that repair work done, but they did it so we could have a lawsuit because there wasn't a leak. They've claimed there wasn't a leak. So it is a question of all of the credible evidence. And in this case, they've failed to give you credible issues that are genuinely before you, that were before the lower court. And so, as I said, I wanted to address here those things that are factual because the briefs have addressed the law. I need to add a couple of things just to point that out. As the record shows, there's a sign on the side of this tank that says something to the effect of it's built according to ANSI standards for a double wall tank. But they deny they knew it was a double wall tank. They came and they did work on the tank. Now, when you do work on the tank and you cut it open, there are 2 layers of fiberglass, but they denied that they knew it was a double wall tank. So at the end of the day, the facts become important, and here there are no credible facts. Again, I might have characterized what the lower court addressed as factual issues and explained it more clearly, but I think as you hear what I say and you read this record, there were no factual disputes in this case because all of the facts were addressed on the documents and on the previous communications, and what somebody creates for litigation isn't the same thing. Thank you.
Thank you, counsel. Case 708, Shelov versus Boar.
Good morning, Your Honors. Justin Hendricks of Kenny Shelton Lipbeck Nowak here on behalf of the defendant appellant. This appeal is a request to have this court perform its own in-camera review of records that were reviewed by the trial court. The trial court came back and told us after their review that none of the records should be disclosed whatsoever. We don't think that's practically possible. We've not admittedly seen the records, but we think we have a good faith basis for why at least a portion thereof, if not entirely, would be discoverable, and certainly to any potential redactions. And
well, let me just see if I can get this straight. The trial court order denied the motion of defendant to compel certain disclosure.
I'm sorry, Your Honor. I don't.
What did the trial court do with respect, in the order, once the trial court made an initial determination concerning the medical, we're talking about medical records here, right?
Yes.
Yeah. And the trial court did an in-camera review.
Yes.
And the trial court made a determination.
Yes.
Okay. And the issue I'm having with this appeal is that we then got involved in motion practice relative to the appeal of that order, right?
I do apologize. I'm not following you. I'm sorry.
All right. Well, there was a determination made that we issued an order here.
Yes.
Right?
Yes.
And the order directed certain things to happen.
Yes.
Right. And had a timetable for those things to happen.
Yes.
Right. And so with respect to the record that's before us, that's what I'm getting to.
Okay.
With respect to the record that's before us, on that, in that order, we said the trial court is to determine whether or not the records that were delivered to the court were the same records the court looked at when the court made its decision relative to the compelling disclosure, right?
Yes.
Okay. And the court certified, the trial court certified, that the court was unable to confirm that the records they reviewed were the same records. There was a passage of time, had no idea whether those were the same records that they had reviewed.
That was the lower court's determination, yes.
Right. Okay. And so then the court ordered that those records be sent to us for an in-camera review.
Yes.
Separately, right. But what we're dealing with here on the appeal is the court's determination initially. That's what the appeal's about, right? The court's determination as to whether or not the records are disclosable.
Yes.
Right. But the court has already indicated to us that the record before us is not reliable. We don't know that the records that are delivered to us are the same records that the court reviewed. The court affirmatively said that it can't certify or can't affirm that those are the same records. So do we have a proper record before us to do a review of the court's determination below? That's my question.
Okay, and my response to that would be that you do, in that the records that the court initially reviewed at the very beginning, I think over 2 years ago at this point,
right,
because the procedural posture of this appeal has been so strained. Those records were provided directly by plaintiff's counsel. A copy of the records in question were provided by plaintiff's counsel to the court, and that review was done. And then the records were, for whatever reason, or longer in the trial court by the time the stay was lifted, and so we needed to get another copy. Plaintiff's counsel, as you said, provided that copy, and the trial court was not in a position to say these were the same records. Then a copy was finally sent directly from Care Treatment Centers to this court. But ultimately, all we want is a determination of those records. And if they are different.
Counsel, I understand what you want. I understand that. Wasn't the procedure, the proper procedure here for the court below, once the court determined that it could not tell whether these were the same records as the ones previously looked at, that the court should start it all over again and re-look at those records and make a determination? Isn't that supposed to happen at the trial level?
The court that I'm currently standing before said that they wanted a copy of the records. So we have provided you with a copy of the records.
We got to make sure that the records we get are the same ones that Judge Panapinto reviewed and said there's nothing in here that's relevant. That's, I think, what the question is driving at.
But Your Honor, why could they and how would they possibly be different but for the other part of this equation, which is where the first set came from?
Let's say, just for hypothetical purposes, the plaintiff's counsel has these records.
We don't. That's not a hypothetical, Your Honor. They freely admit they have a copy.
So, but let's just say the following happens. Plaintiff's counsel says to a paralegal, hypothetically, these are the records that we have to ship over to the judge. And the paralegal, in an effort to get those over to the judge, somehow, some way, 2 or 3 documents are not included. And the judge gets almost a complete set of the records, but not a complete set. Then later on, what happens is it's ordered that the records be shipped from the facility to the judge directly. And the judge says, I can't tell whether this is the same record as the one I looked at before. Something could have happened. So the judge is saying to us, this, what you have before you with this new set of records, I can't tell you whether that's the record that I looked at when I made my determination. We don't, when that happens, we don't have a proper record before us to make a determination. Isn't the solution to have the court below, once the court realizes that you can't certify the record on appeal is accurate, that the court below says, okay, let's do it over. Let's take another look at this record to make a determination.
And Your Honor, I think my response to that would just have to be, again, like, that would just be such a gross misallocation of 2 years of already trying to get to this point. I mean, it's impossible to make this point without sounding like I'm whining, but like,
no,
that would just be terribly unfair.
Well,
you finally have the copy of the records to the court, the body that we want to do the review, because Judge Panapinto has already made her decision on these records.
Yeah, but the difficulty here is that you're asking us to make a determination as to whether Judge Panapinto's review was proper or not proper. That's the appeal, right?
Admittedly, yes.
Yeah.
Yes.
And so we can't determine that unless we know what Judge Panapinto reviewed. That's the appeal that's before us, is the determination on the order, or the determination on the original review of the records. And we've got a judge saying, I don't know whether these are the right records or not. I don't know whether they're complete or not. You can't just kick this up to us and say, you do the in-camera review and make a determination. There's an order that's an appeal to us. That's the decision we have to make on that order.
It sounds like you're comfortable. Our order said the plaintiff shall provide the court with the records from the treatment center.
Yes.
And the first time around, did the records come from the treatment center directly to Judge Panapinto, or was it from plaintiff again?
It was from plaintiff's counsel.
And you're comfortable with that? You're comfortable, and I'm not accusing anybody of anything.
No, yeah.
I'm not saying anything was withheld or anything, but we would know they're not if they come directly from the treatment facility to the court.
We were very much hoping that this entire situation would have been resolved at this point more than 2 years ago, and in hopes of expediting that process. Right. Yes, Your Honor, the agreement was reached. This all started because we sent a subpoena to Care and Treatment, and they came back and said, we do not execute subpoenas. We need a specific authorization signed or a court order. We went back to the court and the plaintiff's counsel and explained the situation. An agreement was reached. The plaintiff's counsel would supply the copy to Judge Panapinto. Right. So the copy that the court now has, that's the first copy that I am aware of has been sent directly from Karen to a court in New York State.
Right, and I get your frustration, and I get your skepticism that there's nothing in those records at all, given the factual background here and the treatment that both parties had, frankly, that there would be nothing in there relevant to enjoyment of life and life expectancy. I get that skepticism and I get the frustration. We just have to make sure that what's with us is the same, that the records are the same as what Judge Panapinto had. So that's really the issue. And can't say I've seen this before.
And neither have I or my office, for that matter.
Well, when you file a notice of appeal and you want us to review records, you know you're supposed to have the records that you're asking us to review. You know that, right?
But that's the whole problem, Your Honor. I don't have those records. I never have.
So when you filed your notice of appeal, then did you go back and make a motion to Judge Panapinto to give you the records so that you could perfect your appeal?
Well, no, Your Honor, because we perfected the appeal and 3 days later the action was stayed because unfortunately the plaintiff passed. And by the time the stay was lifted,
But you didn't perfect your appeal because you didn't have the records.
Well, no, Your Honor, when we contacted the court to ask this question, because it was very confusing to us to be perfecting an appeal on a record when we couldn't provide the records specifically that we wanted reviewed by this court, we were told, no, you perfect with the motion papers, and then you provide the records separately.
And was it even possible for you to get your hands on the records? That was not a feasible option, given that these are confidential. Right, that's the whole purpose of the in-camera review, so you don't see them.
Precisely.
You still haven't seen them.
Correct.
And so you're saying, I can't provide that which I am prohibited from putting in my hands and reading.
Correct. I certainly endeavored to facilitate having the records sent directly from Panapinto's chambers here to this court, but unfortunately by the time I was able to make those efforts, Judge Panapinto no longer had them. Or, yes. That was what we were told.
Yeah, I wanted you to be able to respond to the concern I had concerning the incomplete record on appeal as it may be viewed as an incomplete record on appeal. But thank you for, anything further on the argument?
I guess the only, reading the panel, I can already foresee the necessity of future motion practice to this court to even get that second review to take place, because Judge Panapinto is going to say, I've already reviewed those records and denied your access to them following an in-camera review. Do I need to bring a separate motion to this court to direct?
See, we're not here to give legal advice.
Well, well, certainly, but okay.
Yeah.
Thank you, Your Honor.
You're welcome.
Good morning, Your Honors, and may it please the court, my name is Tyler Garvey from Webster Zani on behalf of the plaintiff respondent, Baroyak. Just to address a few of the issues that were discussed with opposing counsel, plaintiff's office possessed a copy of what we believe to be the records that we did provide to the court, and I believe it was mid-2022. So that's how the...
Let me ask you a kind of a basic question. I don't know if there's a way through this that makes sense. Because this, Justice Lilly couldn't be more correct. This is, I don't know if we've ever encountered this. But when you received the records, I mean, your office physically received the records, they were pursuant, no doubt, to a HIPAA authorization signed by your client, sent to the facility. The facility provided the records. And then you, without taking any of the records out of there, you then supply those records directly to the court for an in-camera inspection.
Yes, Judge, that's my belief. I don't know precisely what the HIPAA authorization authorized to be released, but we didn't alter or change those records in any way.
Well, I'm not suggesting that you did that. I'm just, to your knowledge, the full set of records that you received, you sent to Judge Panapinto?
To my knowledge, yes. Okay. And then we, 2-ish years later, this issue came up again, and we were asked to effectively recreate the history and confirm exactly what we had sent before. And we identified records that we do possess, and we identified a letter that we sent, but we couldn't be 100% sure that these are, in fact, the exact same records that we provided to Judge Panapinto.
The records that
Did she give them back to you?
The records that you received from the facility.
Yes.
Those were, I'm not going to call them original records, but were they certified records?
I don't know if there's a certification, okay, Judge.
Did you make a full copy of those records before you sent them to the court?
We may have, Judge. That's
you don't know that
the issue is the tracing the history of the correspondence was the problem. We have records in our possession and we have a letter in our possession, but it's recreating, here's the exact attachment. It was 237 pages and it was Bates numbered X tax. We don't have that information, and so We indicated that
Let
we
me
believe.
follow up on what you just said so I understand it. When you bait stamped the records from the facility?
No, Judge, that really was just a hypothetical of what
Okay,
we
you
do
don't
not
know
have.
whether you bait stamped them or
Yes,
not?
that's what I'm saying.
And you
we
don't
do
know
not
whether you
have that
copied them after you
information.
bait stamped them?
Correct. We didn't make a new copy of the records after we sent them off. We had an existing digital copy, and I believe that's what was sent.
But you don't believe, sounds like what you're saying is that everything you got from Quran Treatment Center, you turned over to Judge Panapinto. You didn't withhold anything, you didn't cherry pick, you just sent whatever came in, you sent over wholesale, right?
That's my belief, Judge. I wasn't
So
at the
then-
office at that time, so I can't, personally attest to the preparation, but.
And if that's the case, then what we have here that came from Quran eventually, unless you did the same thing with us, we have the same thing Judge Panapinto has.
Well, that's assuming that, that's assuming a lot about how Karen maintains their records. And it's assuming that their custodians faithfully reproduce the exact same thing that, in August of 2024, whenever those were produced, that was produced back in
I got you.
2022. And that's assuming that there's a clerk that's photocopying or pulling records, and I just can't tell you that's the same thing.
You said something about a digital. Did you receive these from the treatment facility from Karen in digital format as opposed to a physical copy of the records?
I can't tell you. I know we possess records in digital form, but I don't
Currently?
know. Yes,
But you don't know whether you converted what was sent to you into digital form?
exactly,
By scanning?
exactly.
Okay.
Can I ask you a question? Did Judge Panapinto give them back to you after she said they were not discoverable? Did she give them back to you?
She did not, to my knowledge. And I think that really gets at the problem, because that's what this appeal is all about, and that's what really should have been requested and preserved, soon in time after the decision was made and the appeal was taken. And that didn't happen, and I think that's why we're here.
Anything further, counsel?
I think you understand the briefs. I just want to note that, first, that these records really, they're not relevant, and it's not.
Well, look, we can't even, we have no way of knowing that unless we know what the records
Sure,
are and whether they're accurate. So it's kind of hard for us to
Just
delve into
based on the
merits.
description of what they are, they're alcohol counseling treatment records that the plaintiff and her husband attended before the incident jointly. This is a personal injury case with serious physical injuries. There are some claims for loss of enjoyment of life as a result of the serious physical injuries that she sustained. There's no allegation of an exacerbation of an addiction issue. There's no allegation of a prior depression issue or any other mental health issue. They just don't relate to this case, and that's why I don't think that it's not inconsistent at all that Judge Panapinto, after reviewing these, evidently decided there's nothing relevant here and/or it's too confidential. I mean, these are, of course, are highly protected.
Well, your opponent doesn't get reply here, but he might be heard to say in response to that it's not your analysis of whether or not these records are disclosable. It's the judge's job to do that with an in-camera inspection. And the judge here did that, issued an order, but now we can't tell whether or not the record before us is the same record before the judge below. That's the difficulty we're having.
Yeah, I agree. And
So we can't get to the record. We can't be reviewing a record that was not the same record as the trial court. So arguing on what was in the record and what it meant is difficult.
Judge, I completely agree, and that makes a substantive review of Judge Panapinto's in-camera review and really her discovery determinations not really possible here. And I think the remedy for that is dismissal of the appeal. There are cases that we cited in our brief that are direct on that.
But counsel still hasn't had an appellate review of the trial court's determination based upon, in some measure, things that were completely out of his control. And, defendant has appellate rights that have not been afforded the defendant.
I agree, defendant has appellate rights, and defendant took their appeal, and it was defendant's obligation to perfect the record. This is not reinventing the wheel. Pardon me. There are a handful of cases I cited in my brief of appellate reviews of in-camera reviews by the lower court and resulting discovery determinations. And in that situation, the records are preserved as reviewed by the lower court and sent up to the appellate court.
So this is a failure of the court system, is what you're saying, not a failure of the defendant?
I plead no
Look,
comment
it was
on
not
that one.
foreseeable, the defendant, I think, it's not terribly foreseeable the trial judge would just dispose of these records when the case is ongoing. The trial judge didn't give them back to you. I'm not sure where they went, but I think reasonable for the defendant to assume that they're still in chambers, but they're not for some reason.
I respectfully don't see it that way. I think that if you take the appeal, that would be one of the first things I would request from the lower court to ensure that that type of thing doesn't happen. But of course, hindsight is 20/20, and that's not my role. And
We'll take a look at that, counsel.
I'm not trying to say that. Thank you very much.
Thank you.
Not arguing, Your Honor?
No.
Do you have a copy? Did one arrive?
A copy, my understanding is copies arrived at the courthouse.
Thank you, Your Honor.
Thank you. Case 709, Providence State Street Housing Development Fund versus Buckingham Construction. Counsel Westbrook, can you hear us?
Good afternoon, Your Honors. I can hear you. Thank you.
Very good, very good. Please proceed, counsel.
Mark McCauley, law firm of Byrne O'Neill, represent appellant, defendant, appellant, respondent, party architecture. May it please the court. We have a case here. I know you have my briefs, and you're somewhat familiar with the facts and the position of party on this case. This is quite simply, as you know, it's an affordable housing project, the Paul Wolk Commons project. The plaintiffs in this case, and that's what we get to, there's two entities we have here. We have East House, we have Providence. We've learned after years later through a motion to amend by East House to be substituted as a plaintiff, we learned that the initial plaintiff's entity, Providence, through a declaration of interest, which sets forth in detail the rights that East House and Providence had in this project, and the fact that Providence had no rights in this project. It was merely named in the deed nominally, but had, we always talk about the bundle of rights, had no beneficial interest.
They signed away
no
their
rights.
They signed away all their beneficial rights
All of it.
to East House.
Right.
Your client has a contract with East House, and in your view, Providence is not a third-party beneficiary of that contract.
Absolutely not. Had no right to claim damages, had no authority to enter into contracts that would be binding on East House, had no rights whatsoever. We learned that through the declaration of interest later. And now East House wants to come in years later, certainly way after the statute of limitations. And the Court of Appeals has already held in the case, the NA Bank case that I cited, you can't do that. You can't substitute in. You can't substitute in, and there's no relation back when you've got when you're trying to substitute it into an entity that has the rights for an entity that had no rights, had no capacity, nor standing to make the rights that it did.
The statute of limitations has run on.
Long since.
The 10-year, it was a 3-year statute of limitations, and 10 years later they tried to amend, is your argument.
That's correct. Nor, and the other argument, the fallback, I'll call it the fallback argument, is that, Providence was an agent. No, you weren't. It says right here in the document you couldn't be an agent. Maybe you could have been an agent, but there's nothing, but Providence didn't sign the agreement. It was East House agreement, so clearly they weren't acting as an agent with respect to party, my client. Now, with the other
Well,
contracts,
Mr.
yeah.
Griesberger was the president of Providence and also was the president of Providence State Street Housing, Inc., which is a general partner of East House. But you would say, so what?
So what? They were affiliates, maybe they were affiliates of each other, we don't know that, but they weren't vicariously liable. There were two different rights with two different entities with two different rights in the project. Okay, maybe there was an umbrella organization, but so what? That's not close enough. That's not vicarious liability. And the Court of Appeals is pretty clear on that. It's got to be that close, right? They have to be inextricably entwined. That's not what we have here. This is just a general corporate a structure here. So that's correct, Your Honor. That's our position.
Anything further?
So aside from that, we also have cross claims asserted by the two parties. I think I can clean those up. Neither of the two entities, Capstone nor Buckingham, contract with parties. So there's no vicarious liability, so there's no indemnity there. And there's no contribution. This is not a property damage case where you have tort-based rights, right? This is a case where we have, as the courts have sometimes say, foreseeable contemplated damages arising out of the project under the contracts that were entered into. That's not what we have here. And then we're like, well, okay, but there's mold, and that's property damages, right? This court has already specifically held in the Gallup case that mold does not turn an otherwise breach of contract case into a tort case. So for that reason, the cross claims should also be dismissed.
Very good.
And I thank you.
Thank you, counsel. Counsel? Who's up? Capstone?
Capstone, Your Honor. Thank you, Your Honor. Chad Flansburgh. I represent the defendant, appellant, respondent, Capstone Construction. Capstone's construction in this role was a construction manager. It's undisputed in the record below that Capstone didn't perform any construction work prior to substantial completion, wasn't involved in the design of this project. Instead, what its role is and what the trial court presumably found was the basis for keeping Capstone into this lawsuit, because the first, second, and third causes of action against Capstone for breach of contract, breach of warranty, and malpractice were dismissed, was that Capstone, because it engaged in some post-remedial efforts of laying a bead of caulk when there was a complaint of water penetration, that somehow that was negligence. And in this case, Your Honor, as we cited in our record on appeal, is that ultimately what needed to be established, among other things, was that Capstone's post-substantial completion work somehow exacerbated and caused an injury. And in this case, it's completely absent from the record below. And we know that the water penetration was occurring and was not caused by Capstone because it was inspected by the architect. We know that from the record, and they certified it was substantially complete. But the water penetration was occurring at that point, and ultimately the bead of caulk was laid. That didn't fix the issue, and there's no claim that it at all exacerbated the water penetration issue.
I'm sorry, Counselor, I don't mean to take you off of that
Yeah,
argument.
absolutely, Your Honor.
Let me go to the indemnification and contribution argument. You don't disagree that all the claims here are sounding in contract, correct?
Yeah, I mean, ultimately, if the court believes that Capstone should be dismissed from this lawsuit.
No. You don't disagree that all the, I mean, that's party's claim, is that all the claims here brought by the plaintiffs or plaintiffs sound in contract, not tort. You agree with that?
Well, yes, I agree, but unfortunately, we do have the fourth cause of action that is named negligence, and that Capstone is in the case on a negligence claim. So when I say yes, it assumes this court's going to say, you know, really this negligence claim is a recast breach of contract claim, and you can't proceed under that.
Yeah, so you would agree that your cross claims too have no, would fail for the same reasons the party says the cross claims fail.
Again, that is assuming that the negligence cause of action, that the trial court...
The fourth cause of action.
Fourth cause of action is not a part of this lawsuit.
Right.
If that is the case, then the contribution claim should be dismissed. I would say that I believe that Capstone would have a common law indemnity claim because it didn't do any work on this project. It
That's
didn't-
against Buckingham that's been severed, right?
Oh, it's also against the architect party.
That's been severed too, right?
It has not been severed.
That one hasn't been severed.
So I would say that, Capstone should be out of this case. And ultimately, if that's the court's position, then I don't disagree with what you're saying. If the court wants to hear anything about anything else, let me just speak quickly as to Providence's claims in their appeal. With respect to the first, second, and third causes of action, there's no dispute that Capstone has not in privity of contract with the plaintiff at all in this case. They're not an architectural firm. There's no third-party beneficiary rights. This is a construction contract. To have third-party rights, it needs to be expressly stated. And in this case, it's just the opposite, that the construction management contract specifically speaks that it doesn't give rise to any causes of action. So with that, unless the court has any other questions, I'll rest on the remaining arguments in my brief.
Very good.
Thank you.
In order next would be, I guess, Ms. Westbrook?
Good afternoon, Your Honors. May it please the court, Ashley Westbrook from the Glennon Law Firm on behalf of Providence State Street HDFC and East House. The Paul Wolk Commons, Your Honors, the building in question in this litigation, provides subsidized housing to individuals in Rochester facing challenges ranging from housing insecurity to maintaining their sobriety. Supporting these individuals is critical work, and New York State recognizes that not every nonprofit that comes along is equipped to do it. To this end, New York requires that Providence surmount significant bureaucratic hurdles prior to allowing Providence to provide supportive and subsidized housing. As the trial court here correctly understood, the umbrella organization Providence was required by New York State to create two separate entities in order to receive the funding and support necessary to establish the Paul Wolk Commons. These entities are substantially the same organization. As the court has noted, they each share common ownership and control of the property, and East House's general partner and the HDFC's owner are one and the same, Providence HDC. They are separate because New York State legally requires them to be separate, not because they are doing different things. They both own the Paul Wolk property. They are both run by Providence. And as the trial court correctly determined, the inclusion of East House as a plaintiff does not come as a surprise and does not prejudice any of the defendants. The trial court, yes, please.
Counsel, I'm sorry if I accept, there's actually three entities named Providence in this.
So,
right.
Your Honor,
And,
there's...
But to narrow this, the defendant's position is the relationship between the two entities that want to be plaintiffs have been clarified and articulated in the Declaration of Interest. And do you disagree that that Declaration of Interest controls here as it relates to the two potential plaintiffs?
So along the same lines, Your Honor, the Declaration of Interest is a New York State requirement that these two entities, first, they're required to be created in this way in order to receive funding for different things that it doesn't have much to do with this case. I think the main...
Well, I understand that, but part of the declaration, there's a provision there that says everyone else who's dealing with these two entities can rely on the declaration. That it isn't just an internal document between two related entities, it's for the rest of the world. And doesn't that...
It certainly does, Your Honor. Thank you for that question. It certainly does outline the relationship between these two related entities. And we believe, Your Honor, that the trial court correctly determined that they were closely related enough to supply the requisite foundation to permit our clients to include East House as a plaintiff here. So as I said, the trial court therefore correctly determined the two entries are closely related, specifically stating that the claims against defendants arise from the same transaction or occurrences and have the same questions of fact. The trial court also specifically determined that its ruling, quote, does not pose any prejudice on defendants. Notably lacking is any suggestion in any of the defendants' briefs that they are prejudiced by the addition of East House. And of course, that's because they simply are not. Defendants are already a party to the lawsuit. These claims are no surprise, and therefore cannot be said to prejudice defendants. Plaintiffs urge this court to uphold the trial court's determination on these issues. These foundational issues largely address defendants' parties' brief. As the court's already discussed, we certainly would argue that there are non-economic damages specifically pled in the amended complaint, including but not limited to property damage, mold, remediation work. We think discovery may bear out that there were lost rents here. There are non-economic damages. That's very clear here. Turning briefly to plaintiffs' arguments regarding Buckingham. As an initial matter, we would argue that summary judgment is not available to a party based on an unpled affirmative defense. As further discussed in our reply brief, CPLR 3015A requires that a defendant immediately and specifically plead affirmative defenses related to conditions precedent, or they are waived. Where they did not plead a condition precedent in their initial answer, Buckingham has waived affirmative defenses regarding conditions precedent. And in their brief, Buckingham fails to meaningfully engage with this argument. The issue of latches is also brought to the foreground, where these affirmative defenses were not asserted by Buckingham during the first 7 years of this litigation's pendency. Plaintiffs indeed did mediate the claims in March of 2019, and of course have provided notice to Capstone regarding the water penetration issues. Plaintiffs therefore submit that this constitutes sufficient compliance with the conditions precedent. Buckingham was aware for years of these facts and did not put them forward in the form of affirmative defenses, and they are therefore barred from doing so now. Finally, Your Honors, with respect to Capstone, Capstone is in contractual privity with plaintiffs, where plaintiffs are a third-party beneficiary of the contract between Buckingham and Capstone. The Logan Baldwin elements are met here because there was a valid and binding contract between Capstone and Buckingham for Providence's benefit, and it was immediate and not incidental to indicate an assumption of duty to compensate Providence if the benefit were lost. Additionally, a duty of care has been assumed here under the Espinal factors, where Capstone has failed to exercise reasonable care in evaluating the construction issues. Plaintiffs also detrimentally relied on Capstone's performance. And finally, Capstone displaced Buckingham's duty by instructing plaintiff to notify them, Capstone, of the issues and by performing the construction of ineffective remediation. Plaintiffs respectfully submit that the Fourth Department should affirm the trial court's order granting plaintiff's motion to amend to add East House, and likewise affirm the trial court's denial of both Capstone's motion for summary judgment with respect to the fourth cause of action and parties' motion for summary judgment in its entirety. Plaintiffs further submit that this court should reverse the granting of Capstone's summary judgment motion as to the first, second, and third causes of action where Capstone assumed various duties. Finally, plaintiffs urge this court to reverse the trial court's granting of Buckingham's motion for summary judgment where they failed to plead conditions precedent as affirmative defenses. If there are no other questions, I'll conclude my argument, and I thank the court for its kind attention.
Thank you, counsel. Mr. Hooks?
May it please the court and counselors, let's make no mistake about it. In Buckingham Construction's original answer to the original complaint, it pled a third affirmative defense that plaintiff failed to notify Buckingham Construction of any defects in its workmanship. This was pled, this condition precedent was pled in the initial complaint, the initial answer. Make no mistake that the moment East House, claiming it was a necessary party, moved to join this action, Buckingham cross-moved to amend their answer to plead that East House failed to satisfy the condition precedent that it mediate before the American Arbitration Association before initiating an action. Both were done immediately. It is a gross distortion of the record to say that we sat on our rights. Number two, it is a gross distortion to say that we are barred by the doctrine of laches. It is the plaintiff who is arguing that with the slew of all these motions and cross motions, discovery needs to be done, hence these motions are premature. You cannot make an argument that any motions are premature, and then at the same time argue that our cross motion to amend against East House is late in the game. There has been enough discovery here to establish through the documents that written notice was never given to us, that there were any leaks. They may have been given to the construction manager. They were not given to Buckingham Construction. This court and the Court of Appeals have said substantial performance of condition precedents don't count. It's one of the few areas of the law where form over substance matters. You must provide written notice, not oral. You must give it to Buckingham, not the construction manager. You must do it within 21 days. I'd ask that the court affirm the decision of the court below, granting Buckingham Construction summary judgment.
Thank you, counsel. The next case up for argument, case 705, Kiatkowski versus Horn. Justice Ogden and Justice Kane are recused. Justice Smith will be joining the panel. Welcome.
What's up?
Let's see who we have here. Well, counsel? Proceed, counsel.
Thank you. May it please the court, Kevin Decker on behalf of Appellant Carrie Horn. In 2021, the Erie County Supreme Court...
Counsel, I'm going to ask you kind of a threshold question here.
Yes, sir.
If you'll allow me to do
Yes,
that.
Your Honor.
We have a judgment, the initial judgment, that's recorded.
We do, Your Honor.
And then we have a renewal judgment.
That's right, Your Honor.
This is not briefed, and I will give counsel an opportunity to respond to this post-argument if you wish. But the second judgment is under a different index number than the first judgment. The second judgment appears to extinguish the first judgment because the two judgments cannot exist separately. It's only one judgment. If the second judgment is deemed to extinguish the first judgment, is that a problem for our court in terms of deciding this appeal? That's a question.
Your Honor, the challenge here is only to the 2011 judgment. So I think, but if I could address that point, Your Honor, we moved actually in the renewal of judgment action to vacate that judgment, and we were told in that case that the appropriate action would be to move to vacate in the original action in this case, and that's why that motion was made back in 2021.
So you've made a previous motion to vacate the second judgment, the renewal judgment.
That's right, Your Honor. It was denied without prejudice on the grounds that the appropriate venue for that motion would have been in the original case. But I'm happy to submit additional briefing on that issue if it would be helpful to Your Honor.
Please do.
There are a few judgments at issue here, but I want to touch on the 2021 termination vacatur, which held that Ms. Horn's termination from the Buffalo Police Department was inappropriate. She shouldn't have been fired, and that she intervened to save the life of a civilian. Critical to that termination vacatur was evidence unknown to the court at the time that the termination judgment was entered, but that in 2009, Mr. Kiatkowski violently violated the rights of 4 black teens during a 2009 arrest, an arrest that importantly happened before the termination judgment was entered and before the judgment was entered in this case.
But did anyone who voted for that law in the Common Council or in the legislature have any personal knowledge of what occurred on November 1st, 2006 on Walden Avenue when this incident occurred?
They didn't, Your Honor, and we're not asking the court to take, to use an analogy from hearsay, we're not asking the court to find, based on Carroll's law, that any of the factual findings in Carroll's law are true, but they were certainly the basis for the judgment, part of the basis for the 2021 termination vacatur. In addition to that basis was Mr. Kiatkowski's conviction and sentence to federal prison for violation.
Mr. Kiatkowski wasn't a party to the Judge Ward action.
No, that's certainly right, Your Honor. And that's why I know respondent talked about, issue preclusion and res judicata in his brief. We're not arguing that any of the factual findings are preclusive. The court doesn't need to accept any of those factual findings as true because they were made in the termination vacatur. But it's undoubtedly true that the termination vacatur is based on factual findings by Judge Ward that Ms. Horn's intervention was appropriate and it was needed because of Mr. Kiatkowski's.
I get that, but it doesn't necessarily follow that Ms. Horn's statements were all true about Mr. Kiatkowski's involvement with respect to, take one example, the brass knuckles, punching him with the brass knuckles. Judge Ward's determination could have been right. She acted as a hero there. Doesn't mean that her statements were not knowingly false.
So I appreciate your Honor mentioning the knowingly point. I think the false point, maybe if the only element for defamation was that the claim had to be literally false, the statement had to be literally false, Your Honor might be right, but there's additional elements here. One of them is that it has to be substantially false. So there has to be a difference in the mind of the listener, someone who's hearing these statements, between the statement that was made and the truth of what actually happened. And Justice Ward's findings certainly are based on whatever the specific factual findings, whatever the specific factual circumstances were on November 1st, 2006, that Mr. Kiatkowski was violently arresting Mr. Neil Mack, and that violence necessitated Ms. Horn's heroic intervention, which should have prevented her termination from the Buffalo Police Department. And in addition to this element of substantial falsity, this is a defamation claim where actual malice applies. Mr. Kiatkowski was a police officer. He was acting within his official duties as a police officer. And we cite Malerba and other cases in the briefs that make it clear that the actual malice standard would apply here. Ms. Horn had to either know that the statements she was making were false or to have reckless disregard that the statements she was making were false.
I think the problem that you may be facing is that you're making a lot of good arguments on her behalf with respect to a lawsuit that's long since been over. The time to make a lot of those arguments, one might suggest, was back when it was pending. There was a summary judgment motion made. Apparently, Attorney Sims, your client's former lawyer, didn't file any opposition papers. She did apparently show up at oral argument for the motion, but I think your opponent's going to get up and say that was the time to be making all of these arguments that you're making now.
So, Your Honor, I think there's 2 reasons why that's not the case. There's 3 main reasons here that we're arguing for vacatur, the combination of these 3 reasons. The first is the 2021 termination vacatur, which respondent is attempting to profit from. Based on factual findings, Ms. Horn was entitled in that case to 21 months of back pay, and her pension was reinstated retroactively. Those are the exact funds that respondent is attempting to collect this judgment on based on those irreconcilably different factual findings. And the termination vacatur didn't exist, obviously, at the time of the judgment in this case. So that's a basis that didn't...
Can't those 2 things be simultaneously true? She was wrongfully terminated, and she defamed him. She defamed this officer.
I think
it's not mutually exclusive.
Right? I think it's not mutually exclusive in theory, but based on the 6 statements that we have at issue in this case, I do think it's mutually exclusive, that those particular 6 statements could have been substantially false and made with actual malice, and in addition to the fact that she shouldn't have been terminated and that she heroically intervened to save the life of a civilian. The second reason, Your Honor, why this issue couldn't have been raised before is that we have here neglect by Ms. Horn's attorney Your Honor mentioned that she failed to submit papers in response to summary judgment. She failed to appear entirely at the non-jury trial on damages, and in both of those cases didn't inform Ms. Horn at all that those proceedings were happening. So we didn't get any testimony from Ms. Horn at the summary judgment hearing. We didn't get anything from Ms. Horn at the non-jury trial on damages because there was no appearance by Ms. Horn's attorney and no notice that those things were happening. Your Honor, the court, one of the main issues here is that the court below failed to apply the appropriate standard, and the appropriate standard is set forth from the Court of Appeals in the Woodson case, and even going back, that was a 2003 case, even going all the way back to 1889, a case that respondent cites, Ladd versus Stevenson, which makes it very clear that the power to vacate is this flexible, inherent power that the courts inherently possess. And that it should be used in the interests of substantial justice. And so when you have a case here where you have the combination of three factors, first, that respondent is attempting to profit from a judgment that's based on factually reconcilable findings, that was based on respondent's own conviction for in 2018 for a 2009 arrest, and that was based on a finding that he was a threat to the life of a civilian in the November 1st, 2006 arrest. That's directly at issue in this case. That's factor number one. Second, Ms. Horn was prevented from mounting a meritorious defense by her lawyer's neglect. And the third factor is that Mr. Kiatkowski's contemporaneous account of the arrest is just inconsistent with any of Ms. Horn's statements being defamatory. The court should have considered, I think, all of those factors, and respondent is gonna get up and suggest that there are limited factors that the court can consider, like fraud, mistake, inadvertence. Those are certainly factors that we agree the court is permitted to consider, but it's not limited to considering those circumstances. And even as respondent only goes as far as saying that those are the only grounds on which vacatur are appropriate. But we have excusable neglect here because Ms. Horn's attorney didn't didn't submit papers in response to summary judgment, didn't appear at the non-jury trial on damages or submit any papers related to the non-jury trial on damages. So even if that's all that's required is excusable neglect, we have excusable neglect here. But the court should be permitted to consider additional factors in addition to excusable neglect, all of the totality of circumstances, consider everything that's in the record, and based on that determination, if vacatur would be in the interest of substantial justice. It's not just a 51-49, yeah, if we could go back, we'd decide this case differently, back in 2011. It's a high bar, it's substantial justice, but we think that bar is met here, and if the court applied that standard, that it would have found the same. We point to Your Honor's statements in the record that Mr. Kiatkowski made in November of 2006, the same month of the arrest. And those statements describe a violent arrest. Mr. Mack, who was the arrestee
A violent confrontation. Mr. Mack was quite, in the
absolutely, Mr. Mack
was quite violent toward the police.
Absolutely, Your Honor, and there's no dispute about that. There wasn't a dispute about that at the time, and that Mr. Kiatkowski describes Mr. Mack as being quite violent at the time, and Mr. Kiatkowski in response describes, at least in his statement, at least two occasions where he hit Mr. Mack, one with his fists.
Well, knocked his hands away, I believe is what it was.
That's what he said.
Put him in a bear hug, swatted his hands away, but the allegation from Ms. Horn was that he punched him in the face repeatedly and struck him with brass knuckles. You're standing by those allegations?
The brass knuckles point, Your Honor, of the 6 statements, Ms. Horn, in her answer at the time in 2007 when this case was brought, denied having made that statement. And it's one of the only statements here that's not a direct quote from Ms. Horn. It's just it's in the newspaper article in which it suggests Officer Horn, her account of this is X, but it doesn't quote her in any way. So the first point is that Ms. Horn denies having made the statements. But I think the additional 2 points are the lack of actual malice, that she saw that this fracas, obviously this was a very volatile situation. There were at least a dozen officers that were present at the scene at various times. Mr. Mack was being brought out of the house. She arrived at the scene and then was approaching Mr. Mack. So everyone is sort of in motion. Undoubtedly, Mr. Mack was kicking around. He was resisting arrest. It was a very violent encounter. And so in that sort of fog of war, fog of battle, it was entirely understandable. And there's additionally testimony from Mr. Mack's son here, Wesley Mack, that Officer Kiatkowski was using brass knuckles in that arrest. So Ms. Horn had a...
Mr. Jacobs is going to get up and say there were 20 police officers there, witnesses, and all 20 said that this didn't happen that
So
way.
I wouldn't suggest that if you're comparing Mr. Mack's statement to the statement of 20 police officers, I don't think that for that particular issue that goes to falsity, but I think that goes to actual malice. If there was someone else at the scene who observed Mr. Officer Kiatkowski using brass knuckles, even if that observation was mistaken, Ms. Horn had a good faith basis to believe that, even if even if the statement she did actually make that. I think one last point on this, Your Honor, is that during in 2008, the Erie County District Attorney looked into this issue to see, if there were any violations of law here. And even at the time in 2008, before the judgment was entered in this case, noted the lack of factual discrepancies in the case here. She said, the vast majority of facts in the record are undisputed. Everyone, including Police Officer Horn, agreed on the basic outline of what occurred, and most particularly, to Justice Lindley's point, that Mr. Mack's violent response to a routine arrest was totally unreasonable and, I'm quoting here, required significant force to overcome. So that has been undisputed for the better part of a decade and a half and even more at this point. The difference, the disputes that were at issue in the termination case were policy disputes about what's the appropriate balance between civilian safety and officer safety. When is it appropriate for an officer to intervene? What sort of arrest tactics are appropriate for where Mr. Kiatkowski is saying he had his hand around his head, neck, shoulders, I don't know. What Ms. Horn, what could be described as, what Officer Kiatkowski himself described as a headlock, what could equally be described as a chokehold, which is now prohibited by the Buffalo Police Department. So those sort of policy disputes just aren't germane to the issue here. It's been acknowledged. The factual issues have been the same throughout. So if I could just sum up, Your Honors, I think enforcement of the judgment here, the number one point, and it's the confluence of these three factors, but the number one point here is that the respondent is attempting to collect Ms. Horn's back pay that was awarded in the termination vacatur based on a finding that he acted inappropriately in the arrest, that he was a threat to the life of Neil Mack.
He would say he's trying to collect his damages.
He's trying to collect his damages based on a factually inconsistent finding that was based on his own wrongdoing in the very same fact that's at issue in this case. I think that there's just a fundamental unfairness there. And that's exactly the sort of unusual case for which vacatur was made. So if there are no further questions from the court, we'd ask the court to reverse.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. It's always a pleasure to be the last one standing, the last one to be grilled.
Counsel, let me just start the way I started before on the issue of whether or not the first judgment was extinguished by the second judgment, and giving you the same opportunity, of course, that I'm giving counsel because we're taking you a little off guard with this, to reply post-argument if you'd like.
I mean, I'd hate to agree with the opponent, but having a great deal of experience with judgments, the purpose of the renewal judgment is really to renew the lien. Okay, a judgment itself, the underlying judgment, enforceable for up to 20 years. But after 10 years, that lien that attaches to real property and personal property, that expires. So the purpose of the renewal judgment was to extend that. I think that even I learned this from the county clerk's office, and take it for what I'm telling you, is that the renewal judgment itself will say the actual statement for judgment that gets filed with the county clerk's office, not the decision or the order of the court, but the actual renewal judgment says and references that one, just as saying that's renewed and the judgment lien is extended. So it's my opinion is that there aren't really two judgments. It is just that this second judgment is extending really the duration of that judgment lien for another 10 years. So
So in your view.
That's
in
my
your view,
opinion.
They appeal from the right judgment, in your view.
I believe so, and I think there was a misstatement by counsel. I don't think he was involved at this stage, but there wasn't a motion to vacate that second judgment. That was their opposition to the renewal, which a renewal proceeding, as the judge correctly noted at that point, was that the sole thing is there a judgment? Is it unsatisfied? If so, you're entitled to a renewal. I think the third element is that it's less than 10, or that it's more than 10 years old. But if those three things, you're entitled to a renewal, the appellant was seeking to challenge the actual merits in that proceeding, which was completely improper, and the judge at that point recognized that and said, you have to bring this in front of, attack the original judgment, which gets to my point, which is, this is not seeking to vacate the judgment for the usual reasons, CPLR 5015. This is, let's go for interest of substantial justice, okay? The appellant wants to argue that a judgment on a court can simply vacate a judgment for any reason or no reason. No, that's not what's been, and I hate to stand in front of a court and say, and I said this to the lower court, I hate to stand in front of you and say, you don't have unlimited power, but courts don't have unlimited power because...
I don't think that's what your opponent is arguing. I think the argument is, based upon the different case law cited in the briefs, that there's a, let's call it a strict definition of when you can vacate, fraud, mistake, the things that are articulated. Is it limited to those items, or is it expanded beyond those? And I think your opponent isn't saying you can vacate for no reason. I think he's saying you can vacate for, those are a list of reasons, but that's not a definitive set of reasons. You can certainly get into interest of justice reasons to expand that list. And I think that's his argument. It's not for no reason. He set forth the reasons during his argument.
And that list has expanded over the years. If you look at LAD, first of all, that again said, here's 5 reasons that you can vacate a judgment. Now that was pre-CPLR, obviously, LAD was. And then McKenna comes along and it reiterates what LAD said. Woodson comes along, doesn't say anything about McKenna or overturning McKenna. What it does is actually applies McKenna. That's the key thing here. There is no different, it's not that McKenna's been overruled. Woodson is completely consistent. Number one, keep in mind that in Woodson, the court said, it's been 10 years, you're too late. Okay? And that goes along with all the case law that we've cited, which is, listen, you have a limited, there is no specific deadline for bringing these types of motions, but 5 years is too late. 5 years is too late, reiterated by every court in the state over and over and over. 5 years, too late. Court of Appeals in Woodson, 10 years, too late. Also in Woodson, it was because there was no fraud, misrepresentation, those types of elements, which the Court of Appeals said was required in that case. So Woodson isn't contrary to McKenna. It's completely consistent with McKenna. And then there are subsequent cases that are also applying McKenna. And I point out to your honors that actually I hate to cite case law that wasn't cited in the briefs, but after this case was fully briefed, there happens to have been a case out of the second department directly on point. Says Woodson and McKenna read together, you have to have the McKenna factors, okay? That is HSBC Bank versus Pacifico, 2024, Westlaw, WL 3801404, decided mid-August 2024, just after all of this was, and that's what it says. It says McKenna wasn't overruled by Woodson. They are read together. They are one and the same. And in this case, you don't have any of those McKenna factors. Number two, the most important thing, I think, is really the untimeliness. This is 12 to 13 years, depending which judgment you're looking at. And these judgments are on the merits. The appellant was represented throughout that lawsuit by counsel. Counsel, and again, look at that decision from Judge Marshall, and where he says, it wasn't that she didn't submit papers. It's pretty clear that she didn't submit them timely, okay? And the judge, and it's interesting here, again, that the appellant waits all of these years, counsel are dead, judge is dead. Everybody's passed away. Oh, let's challenge it now. And let's challenge it now politically. That's a big thing, getting back to some of the things that were discussed as far as the facts underlying this. I don't want to get into the facts too much because the briefs fully set forth the facts. But Mr. Mack, it's undisputed. No injuries. 0 injuries. Supposedly being beat about the face, beaten with brass knuckles. Didn't go to the hospital. Was not injured whatsoever. Sued.
Right, well, she would say.
No cause.
Ms. Horn might suggest that, but for her intervention, he might have been injured.
But that wasn't the defamatory statements weren't, he attempted to, he was about to, it was that he did these things, okay? And that is the big key thing here, if we get into the underlying claim, is that, that these statements can be false
Right, well,
at the same time.
Now, I mean, in hindsight, it appears that this officer, Kiatkowski, had the willingness to engage in such type of behavior, assaultive behavior, and that he was convicted of federal court of violating the rights of African-American, 4 African-American teenagers in 2009 by engaging in violence, and he'd served time. But in your view, that mere fact that he did something of a similar nature later doesn't necessarily mean he did it before?
That's exactly right, Your Honor. One incident doesn't necessarily say what happened in the prior incident. And the fact of the matter is that the facts are undisputed in this case as far as what occurred with Mack. 20 separate incidents, including at the end, when we're talking about the political decision to pass Carriel's law. Keep in mind, read those articles from the mayor, Byron Brown, who's still the mayor to this day, saying, I fully support the purpose of this law. Just don't name it after her because she's a bad cop. That's what he said. Everybody's forgotten what's happened in this thing in 2006. Same thing with the several council members. We support this. Just don't name it after her. And then when it came time, of course they did vote for it. And then Judge Ward's decision, there was no, again, the political fix was really in. They were trying to get a pension, which admittedly the appellant was only a year and a half
So
from.
can we please stay with the legal arguments here and not political fixes and those kind of things?
I'm sorry, Your Honor.
Yeah.
A political determination was made, and they passed Carriel's law. She was able to get, and Judge Ward applied that law, but without any opposition. Nobody opposed it. So it's not, every time that there was opposition, when there was a contested proceeding, 20 separate times, as I've gone through in my papers, her version of the facts was totally rejected by everyone involved. So at this point, Your Honors, there's other arguments that are, of course, made in the papers, but I think the 2 key arguments have been addressed, and it's pretty clear that the lower court did not abuse. Keep in mind, that's the standard, abuse of discretion. The lower court didn't abuse its discretion, therefore, its order should be affirmed.
We'll take a look at that, counsel. Thank you.
Thank you.